And also good morning to our guests, Mr. Songelwa and Mr. Charakupa. Good morning and welcome to Parliament. And good morning and welcome to our colleagues from Parliament, from the Auditor General, and also members of the public here. The first thing I want to do is to apologize for our late start. There have been significant logistical and service delivery problems that Parliament has had to engage with. Just for your assurance, we had our own challenges here, Mr. Songelwa and Mr. Charakupa, that affected the members significantly. So a lot of the members could only arrive quite later than usual here. But we thank you for making yourselves available to assist with our inquiry. So the first thing I will do is to ask Ms. Ibrahim to just explain the rules of Parliament that govern this inquiry and swear you in. But before she does that, I just want to say this is not a trial. This is enhanced oversight. You will note that we don't even have an evidence leader here. As you see in some other parliamentary proceedings, we are not going to make a finding of guilty against individuals. That's not the point of this inquiry. We want to understand issues at the Road Accident Fund within the terms of reference, and we are inviting various people to assist us with what is within their personal knowledge, or where you've come across information directly and so on, that you share that with the committee in order to develop our understanding. The committee will consider all the inputs, including inputs from the public, in their totality, and then make recommendations that are going to assist the Road Accident Fund in terms of its work going forward. Some of those recommendations will go to the ministry. Obviously, the whole report goes to the ministry, but I am certain that there will be recommendations for Parliament, committees, for the ministry, for the Road Accident Fund, and so on. So you are assisting a bigger scheme that we are doing as this committee. So thank you very much for making yourselves available. Ms. Ibrahim, let me hand over to you to dispense with the formalities, and then we can get started.
Good morning, Chair, and good morning to all of the honourable members and colleagues that are present here today. Mr. Songelwa and Mr. Charakupa will be happy that they don't need to deal with me after today. I've been on their case for the last few weeks. Gentlemen, you've been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, read together with National Assembly Rule 168, which provides you certain privileges to appear before the Standing Committee on Public Accounts as a witness in respect of the committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or imprisonment for a period not exceeding 2 years. Mr. Songelwa and Mr. Charakupa, you've both indicated to me outside of the meeting that you would like to take an oath. So, Mr. Songelwa, I will start with you first. If you could please raise your right hand, sir, and repeat after me. I swear that the evidence I shall give.
I swear that the evidence I shall give
shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the whole truth.
But the truth, yes. So help me God.
So help me God.
Thank you, sir. Mr. Charakupa, we're going to do the same. If you could kindly raise your right hand. I swear that the evidence I shall give
I swear that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Gentlemen, you are now sworn in for the duration of the proceedings, including when we come back for the session later this evening. Thank you.
Thank you very much, Ms. Ibrahim. A couple of housekeeping issues. So we keep trying to simplify sort of the process for the members. So we have prepared a physical bundle for the members, which I hope all of you have. I think you must have heard Ms. Ibrahim saying that she hopes that this is I'm sure this is the last time you're hearing from her, and that's because the two gentlemen deal with numbers, and most of us are not numbers people, and they're also very finicky about numbers. So they've corrected certain information that is in the main affidavits by providing an additional 2 pages, I think it is, so that when we're going through the affidavits, we've got the right figures to a decimal. So I just want to place that on the table. So what we will do is that I will ask some questions for introductory purposes, really, with both of you, so that we can locate you and some of the information in the context of the bigger inquiry. And then I will hand over to the members to ask questions. They've got all the documents that have been provided either by yourselves or provided by members of the public and provided by the Road Accident Fund. So they've got the benefit of a big bank of information. The members have had an opportunity to read through the affidavits. They've got them in front of them. So we won't do chapter and verse of the affidavits at all. So what we will attempt to do is to just briefly deal with some of the key parts of both affidavits. Unfortunately, they overlap. And so we can deal with matters at the same time. We had 2 witnesses the other day, I think on the first day of last week. It worked very well. So what I would encourage you to do, so that we save time, if one of you has something to add on the same, you simply indicate to me that you also want to add, so that we don't then later ask either of you the same question. Otherwise, that's going to take long. We will take a break, say at around 11:30 thereabouts, for 15 minutes, and then we will return, break at 1, and then we will come back in the evening. The last thing I want to say is that please take a deep breath, relax, use as simple a language as possible. Where there is an acronym that we won't understand, we will not feel patronized if you say it out in full and explain what it means, right? Otherwise, there is a possibility that we may then misunderstand the meaning of that acronym, especially things that are profession specific, that are organization specific, that are sector specific. You find that there's the same acronym elsewhere. So please do that. I may occasionally just ask you to explain what something means. So I may stop you and just ask you to explain what something. So please be patient with that. Otherwise, once we're done with the initial introductions, I will then hand over to the members. Each of the members will have time with either of you to just have a direct exchange. And then at the, when that time expires, then another member takes over, and then we break as planned, and so on. So thank you very much. The first thing I will ask you, both of you, to do in turn is to just do an introduction of yourselves, as you've done in the affidavit, but the public don't have the affidavits. So just what your role was at the Road Accident Fund when you were there, what the role entailed, and that sort of thing, and then we'll take it from there. No. You can start, Mr. Songelwa, because you are closer to me. You can use the...
Thank you very much. Good morning, Chair and honorable members. My name is Victor Songelwa. I am a former general manager from the Road Accident Fund. I have acted as a CFO on various occasions. I'm coming in to make a presentation during the time I acted as a CFO. My contract came to an end on 30 September this year. I will explain later on that part. As an acting CFO, I was responsible to provide leadership and strategic guidance in shaping and oversee the strategy, overseeing all financial activities and financial reporting aligned to PFMA and Treasury regulations. I also ensured effective governance and regulatory compliance to preserve RAF's assets. I will leave it there, and thank you very much. Thank you.
Thank you, Chair. Good morning, honorable members. My name is Charakupa. I was a senior manager of the actuarial unit at the Road Accident Fund from September 2013 to 2022. I was to 2023, sorry. I was responsible for actuarial valuations of the claims liability, also the funding model in terms of the projections of both the liability and the expected revenue. I was also responsible for the reinsurance and insurance program at the Road Accident Fund. I think I will stop there for now, then I will explain as we go. Thank you.
Thank you very much. Mr. Charakupa, can you just say what the actuarial, what purpose the actuarial professional practice at the Road Accident Fund serves? You know, in its fullness, what purpose it serves, how does it help the fund and other functions of government?
Thank you, Chair. So the actuarial function serves a number of purposes. As actuaries, we deal with numbers and we try to make financial sense of the future. So what we do, we analyze numbers in the context of the Road Accident Fund. It would be the claims, the historical claims, the settlement patterns, the reporting patterns, and we then compile reports on the claims liability, right, which would be how much is owed by the Road Accident Fund to claimants, those victims of road accident or beneficiaries of deceased breadwinners. So what you want to quantify that amount and inform the RAF management and the RAF board to say this is what you should expect to pay in claims over, be it the next year, the next 2 years, the next month, just so that for their budgeting and the planning purposes, they know what's coming. Once claims are settled, they would know that this is the budget we needed, and they plan for it. And ideally, you would want them to have resources to pay those claims as soon as they are settled, because these would have been people who are injured or who would be, bedridden or who would be in hospitals. So the idea is to assist in terms of that financial prudence aspect for entities which deal with claims. I think that concept also goes to insurance because they also deal with claims. So the quantification of claims liability is really for that purpose, to say how much money do you need it, when, and you then put in place plans to have that money ready for payment. And then on the funding model side, you are then saying this is the fuel levy or any other revenue that is coming in. If you compare that with the claims liability expectations, outflows of that, is it matching? What is the gap? And that gap, management and the board is aware of it, and then they can also inform the ministry and National Treasury, again, so that the government can make informed decisions. If the funding gap or the shortfall is persistently high, or it continues to increase, then the Department of Transport and the National Treasury can then either decide to increase the revenue allocation given to the Road Accident Fund to meet those obligations, or they can decide to speed up legislative amendments to change the law if they feel is the benefits are too high and the country cannot afford those. But the idea is the road accident victims should be paid for a very long time after the injury. So in short, I would say in that context, it would then assist the board, management, the department, and National Treasury to make informed decision in terms of what's coming, in terms of claims obligations, and on the other side, what's available in terms of the available funding.
Thank you. Can you thank you for that. Can you then give us a sense of how your two roles interacted with one another in service of the Road Accident Fund? Because as I understand, Mr. Charakupa, you reported to Mr. Songelwa. Would that be correct?
That is correct.
That's correct. Okay. So, Mr. Songelwa, just explain to the committee how basically, because you were in the finance function either as GM or as acting chief financial officer. Can you just give a sense of what this interaction was and this interdependence was, and where and basically how it worked with the total accountability system within the organization?
Thank you very much. So the claims liability forms a major part of the financial statements at RAF. It is actually a major component. It's a major component in the income statement in the form of claims expenditure. It's a major item in the balance sheet in the form of a claims liability. And so for us to have a value that is valid, accurate, and complete, actuaries would play a very, very big role. And for us to have assurance that indeed the number has been tested, is quality assured, we've got 3 levels or 3 different entities of actuaries or role players. The first one would be internal actuaries, which was headed by Itai. The other one would be statutory actuaries. It's an outside service provider that provides a statistic, or rather actuarial values of the claims liability on a quarterly basis. The other one is a peer review actuaries. They come once a year just to look into the overall and say, after a year, are these three rather functionaries, internal, statutory, what are the results? They come with a number independently. So the 3 numbers are now compared and see if indeed both internal and statutory numbers can be relied upon. Then we use that information at year end for financials and reflect them in our financial statements. Thank you.
Thank you. So are there any other people who perform an actuarial function at the Road Accident Fund?
Yes. As I think... to clarify, so there's 2 actuarial divisions in the Road Accident Fund. The corporate actuarial, which is the ones which deals with valuations and funding model and other corporate-related financial impact analysis at the overall level. And then there is the department which deals with individual claim calculations, which is quantification of individual loss of earnings, loss of support claim files for individuals who are filing for compensation from the Road Accident Fund. So historically, I think that role used to be done outside the RIAF, and then I think back in 2021, that function was insourced, and that's a different department. But the issue is they deal with individual calculations for claim files for each individual that is filing for loss of income claims.
Okay, thank you very much. So to simplify, if claimant A says my loss of future income is 20 million, the Road Accident Fund's internal actuaries would also do a calculation. They may come to a different view and say, no, it's not 20 million, it's actually 8 million. And these are the reasons why. And then just switch on your mic so that when you say correct, people can hear you.
Yes, that is correct.
Okay, and then that information is given to the attorney who is dealing with the matter in court.
100%.
And they use it to motivate for a judgment that is going to reflect the view of the road accident fund.
Correct.
Okay, so that's what these people do. So you guys, you were the big boys. You dealt with hundreds of billions, I see, in your affidavit. The other people dealt with millions and tens of millions.
No, we're not the big boys. We're the same. We're equal.
Okay. Okay. No, I have a friend that works, a few friends that work for the Revenue Service. And, they usually say to me, you guys deal with small money. We deal with trillions there. So, okay. So, just a few more questions. So, then a decision is taken to no longer use. So one of the things that Scopa has dealt with for a long time, even before the 7th Parliament. It's been in the courts and so on, and that is the issue of the change in accounting policy. So in order to help you, we are not here to litigate the technical matters of who's technically right. We follow the legislation as it is. What we are looking at as committee is whether the decisions taken have had an adverse financial impact on the road accident fund and claimants, number one. Number two, whether monies spent on various processes were therefore justifiable. So that is the purpose of us discussing this topic. And so I may stop you when you get too passionate and you get too much into the technical matters, because that is not our purpose. So I just want, just in summary, so it appears to be a relationship between the accounting policy and the actuarial modeling and valuations, right? Can I just ask both of you, and you can start, Mr. Songelwa, just give us a brief history and basically what the change in material terms meant, and what's the relationship between the actuarial issues and the accounting policy and so on. And then from there, we will then move to operational decisions and operational impact, and then hopefully we'll wrap up soon and the members can join.
Thank you very much, Chair. Just as a background of we're talking about change in accounting policy. So the claims liability is made up of 3 parts as it stands. If you look into our balance sheet, you'll find that there's 3 categories that make the claims liability. The first part is what we call RNYP, we said the acronyms. It's a claims requested but not yet paid. So a claim has been submitted to RAF, it went through the process, it has been passed, in other words, an offer has been made, and it's actually been requested for payment. If money was not a problem, and the repayment is got to be paid, say, within 180 days currently, when it reaches 180, that money must be paid, for example. I'll talk about 180 and what historically the payment terms were. So your RNYP are the claims that are ready for payment, really. The second layer is what they call ORC. It's open reported claims. The claims have been reported to RAF, and you can actually count them and see there this number, say 300,000 in total, then the boxes there. And what is outstanding with them is that an offer has not been made. So in other words, an offer has not been made, is still at negotiation stage between the RAF and the claimant, or whoever is representing the claimant. That's ORC, open reported claims. The third leg is IBNR, incurred but not yet reported. Accidents have happened. Because the triggering thing for liability for AF is happening of an accident in terms of the RAF Act, not necessarily all the accidents qualify for a liability. So a probability is made that this one will qualify. Say, for example, given 100 accidents, you might say 80% of them or 50% of them will qualify. So your IBNR will be the number. We go to RTMC, request for an accident report, and then we can see that those ones have not been reported as yet. Then a contingent liability is raised on the basis of that IBNR. Those are the three categories. Just to summarize, RNYP, ORC, and IBNR. This was the situation up to 31st March 2020 with these three categories of liability. As of 2020, RNYP, I come with the numbers, was X amount, or RC was X amount, and IBNR X amount. And in total, the liability as at 31st March 2020 was in the tune of, thank you very much, was in the tune of 331 billion. I'm rounding it off, 330.7, but 331 billion in total. That was the total claims liability, made up of these three categories. And then in March 2021, there was and as I say, RAF, we follow the law in terms of what GRAP says, what RAF Act says. In 2021, there was a proposal for a change in accounting policy. What had happened is there had been a new accounting standard called IPSAS 42. IPSAS, International Public Sector Accounting Standard, number 42. These are developed, when we say IPSAS, they're developed by International Public Sector Accounting Standards Board, as opposed to South Africa. The South African accounting standards are developed by Accounting Standards Board locally, so but the overseas one. So the IPSAS 42 was addressing the social benefits. And there's been a debate or just a view that RAF is a social benefit, and therefore IPSAS should apply to it. The approach of IPSAS 42 was a very interesting standard, and my view is that it was introducing, if I may say, the governments at Department in South Africa are not using GRAP. So they're not using the accrual accounting system. They are using what they call cash modified accounting. So my view is that when IPSAS was introduced, it was at least to introduce the government entities, say, for example, Department of Social Development, that is a social security entity, pure, or social benefit entity, pure, that they would perhaps buy into the IPSAS 42 to at least recognize the liabilities that are due within the 12 months. Because as of now, they don't. They just use the cash modified kind of thing. RAF was ahead of IPSAS 42, in my view, in terms of they are using accrual kind of accounting, which is all other SOEs are using. Therefore, your IPSAS 42, because of that limitation of just saying account for liabilities for the next 12 months, ignore anything beyond month number 12, for example, 13 and beyond. It's a long-term liability. But coming back to the point, then in 2021, RAF says were social benefit, IPSAS 42 applied to us. I will not get to the politics, so I believe it went to court with AGSA. Then the change in that accounting policy then said you recognize current liabilities for a short term, for the next 12 months. Beyond 12 months, you do not recognize them. It's a standard. It's written like that. And the challenge was, then ASP saw this standard, obviously, and what ASP does is they adopt the international public sector standards and convert them for the South African, or tailor-make them for the South African environment. So they then said, and they issue a directive saying that we've got this list of standards now, you can use this one. IPSAS 42 was not there at that point in time, because ASP had looked into IPSAS 42 and said it is not ready or conducive for the Southern environment. They will have to tailor-make it and adopt it, and they communicated that to the entities. And then what happened then, IPSAS then was adopted, and it resulted then in the reduction of the claims liability. In other words, your ORC fell off, your IBNR fell off, a new category was introduced called the ONYR, offers made but not yet requested for payment. Remember, I've said now, the first one was RNYP, claims have been settled, offers made, and they are requested for payment, they're ready to be paid. This other layer is same, offers have been made, we know the amount, but what is just outstanding is to request them for payment. So they are as ready as claims requested for payment. Just fine-tune as a question of requesting in finance that they must be ready for payment.
Sorry, Mr. Songelwa, so I'm going to stop you here because I need us to walk slowly through the accounting principle of I will say broadly is provisioning for a liability or an expense in accounting terms, right? So I just need you to help us, just as an accountant, because I think it's important when we get to, so one of the reasons this piece of information is important is that on the first week, we dealt with colleagues, your former colleagues, who are working on the integrated claims management system. And there was a discussion about which documents get loaded. Do they recognize claims at a certain stage or not? And how does it therefore impact claimants and so on? So it's important. So what you are saying is that this calculation enabled the Road Accident Fund and government to work out how much money they may need to make available over the coming period in the event that those claims are made, right? And you look at various other factors, severity, types of injuries, I would imagine all of those things go in there. Okay, so that's the one point. So when you say that the new change said that there now needs to be an offer made, it means, and please tell me if I'm wrong, it means that there may be a claim that Honorable Madlala has submitted. It's known, it's quantified, there is not yet an offer to Honorable Madlala, right? For the purposes of accounting, the Road Accident Fund, in terms of the new policy, still says that claim does not exist for the purpose of accounting. Would that be correct?
That would be correct, Chair. Definitely. In fact, I was going to give the numbers. The change in accounting policy would actually result in the understatement of a claims liability. And in accounting, and I will not get technical, I'll just say, we need for an item to be booked into the financial statements, a liability. So what you do, you first define it, you measure and recognize it, or you recognize and measure it. I won't bore the members, I'll just say, just get a definition. So what we do, we say, let's just say, what is a liability? So we're testing the ones that are excluded, for example. You'll say a liability is a present obligation. So very, very important. So there must be a present obligation. We say that the fact that RAF access when accidents happen, or that RAF is taken, it indemnifies the wrongdoer. That in itself means there's a present obligation when an accident happens. Second part is a present obligation of an entity as a result of past event. In other words, it must be a past event to trigger the liability. If there's no past event, the result of past event, which will result in the outflow of economic benefits, that will make the payment. So what we're saying is the claims, we first test them, whether do they meet this definition. So we found that they meet them, including the ones that are excluded. So the problem is with the new standard is that if we are saying that we are recognizing two categories only, the RNYP and the offers not yet requested for payment, and exclude the ones, for example, that in courts and we then already have understated the liability. That is the issue. And then from an accounting point of view, when you do the reporting, you've got a liability that's only showing the current portion of it as a long-term part of it. So for decision makers, including, for example, the National Treasury, where we expect some increase in the fuel levy because our liabilities are always more than our assets, it sort of shows a lesser liability, and we've seen this. I'm not saying it's a reason for us not having gotten the increase in the fuel levy.
No, so we're going to get there. Okay. I just do need to just please just allow me to work through. So I'll make a different example for emphasis.
Yes.
If, let's say, Transnet is sued for 500 million.
Yes.
The matter has been argued in court. We are now awaiting a judgment.
Yes.
The financial statements are finalized
Yes.
before the judgment has come in. Does, in terms of accounting standards, does Transnet have an obligation to put that in the financial statements?
They have yes, Chair. They have an obligation to put that condition or that transaction in their financials. It is called a contingent liability, in the sense that there is a potential liability for them. They don't know how much it will settle for. They don't know when it will settle and the conditions to it. So to answer you, they definitely have a duty to put it in their books as a contingent liability. Without doing that, they would be misleading the users of financial statements because the people would not know that information. So to answer you, yes.
So in other words, the users of the financial statements who might be lenders, who might be the Treasury, who might be Parliament, must know that potentially in the following year, it could be immediately after, right? Even though we've reflected a profit of 2.5 billion, 500 million may leave the door. 500 million or less may leave the door immediately. We don't know yet, but we're going to put it in the financial statements. Is that correct?
Very correct, Chair.
So let's come back to the Road Accident Fund. So what you are saying is that the new accounting policy, so the equivalent at the Road Accident Fund,
Yes.
is that there is a claim. It's already in court.
Yes.
We know that Honorable Madlala is asking for 30 million. Are you telling this committee that the new accounting policy would then say that claim must not be put in the financial statements?
As long as that claim, Chair, it's not an offer, not yet requested for payment. In other words, we end at the point where the offers are made. If no offers made, we don't recognize those claims for the reason that I've mentioned there. So to answer you, yes, all the claims where no offers have been made are not included in the liability of the RAF.
Okay, now I just wanted to understand that issue. Okay. Can you help the committee then understand, so specific question, which bodies can set accounting standards in South Africa?
There's only one body that sets the accounting standards in South Africa. It is the Accounting Standards Board. And that's the only, for actually, let me qualify it, for the public sector though. For the public sector, it's Accounting Standards Board.
So can the Auditor General set a standard?
No, they cannot. AGSA cannot set the accounting standards for the reason that they audit them. So they cannot be a referee and a player at the same time. It would be actually a challenge in that you are part of a standard setting and now you audit it. So the auditors are independent. The ASB will set the accounting standards. Entities will implement the accounting standards. AG comes and audits them and express an opinion on those standards. To answer you, it's AG cannot make any changes or set standards.
All right, thank you very much. I understand then that an opinion was sought or advice from an external technical advisor. Can you just take us through that and what happened to that advice and then what happened subsequently?
Okay. In I think it was April 2021 when the opinion was issued by, I was then April 2021 General Manager Finance, but working with the finance team. We asked the Internal Audit Department to source a service provider, because why we ask internal audit, they've got a database for service providers, for auditors that assist with capacity when there's a need. So we wanted to get an opinion. If we're to make the change in accounting policy, what would be the issue? An audit firm by the name, I don't know whether to mention it, by the name of Mora Accountants, they offered an accounting opinion about the implementation of the new accounting policy. Their view at that stage, they said it would not be wise of the RAF to change the accounting policy for the reason that the Accounting Standard Board had made it clear that they were looking into the IPSAS 42, that was for social benefits, and they felt that in its form, it cannot be implemented in South Africa. It needed to be looked into. And what ASB does is they communicate when they make when they develop standards. For IPSAS 42 would then be communicated to the community, who would have the input, and then later on that IPSAS 42, later on you see it as a GRAP standard actually. The latest with IPSAS 42 is that it is in an exposure draft form by Accounting Standard Board. It's AD 205, where they think that by 2026 it might be ready. So to answer you, IPSAS 42 would not have been implemented because ASB was working on it to convert it and it becomes a GRAP only when ASB had adopted it and approved by the Minister of Finance, because accounting standards are signed by the Minister of Finance. Only then it would be implemented, if I may say. My view, high level.
Sorry, let me just do it this way. So the opinion said, so Mora Incorporated said that the Road Accident Fund, in their view, must continue using the standard set, must continue to base their internal policy on the existing standard set by law by the Accounting Standards Board. That's what I'm understanding you to say.
Very correct, Chair. Very correct, Chair.
Okay.
In fact, they said continue applying the accounting policy that you've been using. That's what Mora accountants say, until there is a new direction or change by the Accounting Standards Board. And that was very clear in the opinion of Mora accounting opinion.
Okay. So there's a copy of that advice. It's an annex in the bundle. What then happened to that opinion, and what happened subsequently? Because the accounting standard was nonetheless, the accounting policy was nonetheless changed. So this opinion is given. Where does it go? Does it go to the board? Because only the board can change policy. Was it taken to the board? Was it aware of it? What happened to it?
I do not have a record of it being taken to the board, but what I know is that then another accounting firm, audit firm, was appointed to now not give the opinion, but rather review, because management had taken a decision that we are changing the accounting policy. It is a management prerogative, and the thinking then was in terms of GRAP 3. And so the other audit firm then did not now give an opinion, but instead what they did, they issued their review, their report in 1st June 2021. It's in my affidavit. I'll quote the numbers. I don't know whether I can mention the firm as well, PwC.
Yeah, no, it's all, if it's in the affidavit, it's on the public record.
It's a PwC, where they then, I must say, they didn't really express an opinion, but instead reviewed the information they were given. And based on that information, then they went ahead and the accounting policy was then changed. But what I wanted to highlight and emphasize was that Mora offered an opinion. PwC did not offer an opinion, but instead reviewed, because they were told a decision has been made. All you need to do is review the financial information.
Okay. Now we will ask the management and board of the Road Accident Fund to then explain when things change between the Mora opinion and the time that the accounting policy changed. What we do know, because we asked, is that they never took legal advice on the matter, but it was important to close the loop between the two, because it ended up in litigation with expenditure as a consequence. Okay. So we've now worked out, so far, we're going to be done soon. So we've now worked out that even if a claim has been lodged, it's registered, it's in court, we have an idea of how much that claim could be if it's paid out at the level at which the person is claiming, right? It was still not put on the books, even though accounting practice says at that level. And I mean, I'm not even talking about the actuarial valuation now, I'm talking about something that is in progress. So the impact of the accounting policy was such that from the actuarial all the way to something that was already in play and was in the system within the organization, it was then not recognized anyway for the purposes of the financial statements. Okay. So one of the, and I think it's in both your affidavits, Mr. Charakupa and Mr. Songelwa, one of the things you explain is that over time, which is important for this committee, two things happen. One, the number of claims that are registered and finalized drops significantly, one. And secondly, the average amount of money paid per claim shoots up. So in other words, for far fewer claims, for much the same money, basically you pay far fewer claims for much the same money, which would suggest that the Road Accident Fund is now leaking money. Can you just, both of you, just take us through that and why you believe that situation arose and what the financial impact on the Road Accident Fund has been?
Thank you, Chair. Maybe I think, as you said earlier on, to say if I need to add on the part, then maybe let me just add on this part of the change in accounting policy in terms of the practical quantification, and then close that part, and then we just move on to the second part once and for all. Right. So I think I will refer members to paragraph 52 of my affidavit. I think it's on page 14, paragraph 52. And there's a diagram there. Which it's labeled figure 2 at the top, rough compensation claims registration, a processing and settlement process.
Yeah.
Yeah, so if we are all there, so what we have there is just an outline in terms of a claim, right? A claim is triggered by an accident. So the very first arrow at the bottom there is labeled accident date. Right. Then from accident date, the next arrow is registration date. Right. And at the top there is labeled A, which says transit, because between accident and registration, the claim has not yet been recorded on the RIF claims system. So that claim is in transit. So that's first pillar is claims in transit. And as Mr. Songelwa already explained, that's the component that was referred to as IBNR, which is short for incurred but not reported claims. So these are claims which have not hit the RIF system but are in transit. The people are already injured. RTMC has statistics in terms of fatalities as well as injuries, serious injuries and minor injuries. So then that one is a purely actuarial calculation based on external statistics, not in the RIF system, because it's not registered. It's before registration date. Now, the second category starts from registration date to settlement date. At the top there, it's labeled B, which is the processing stage, right? Now, these are the claims which have arrived at the RIF registrations department, right? And then they come from registrations. The next step there, they go to verification and validation. I think the gentlemen who were here in the first week, they explained that process very well. Registration, verification and validation, they referred to as V&V, merits assessment, quantum determination, and litigation. So all the claims that are in these pillars, there's claims that are at the registration pillar, there's claims that are at the verification and validation pillar. People in that department are working on those claims. After they've verified those claims, they move to merits assessment. So there is also a bunch of claims in the merits assessment department. And then they also go to the quantum determination, where the claim amount is determined. And if there are no issues from quantum determination, it then has an offer. Or if there are any issues, it then goes to litigation. When settlement is agreed, then there's an offer, right? Once there's an offer, we are now at settlement date, which is that third arrow. So some claims now have offer, but they are not yet requested for payment on the system. So that's C1, which Bravik, Mr. Songelwa referred to as ONYR. That's C1. Those are claims with offers but not yet requested for payment on the system. Then we have C2, which is RNYP. So these have offers and they have been requested for payment on the system, right? So the change in accounting policy pretty much then said the only claims that you look at is those in category C, which I have labeled there as payment stage, right? C1 and C2. That's the claims that now make it to the RIF's financial statements. At the bottom, you can see a red arrow there, which says IPSAS liability. So it's showing you that only category C claims are now considered a liability on the RIF financial statements, whereas previously that blue line, which says IFRS 4 based claims liability, which starts from the accident pillar, which includes IBNR, ORC, C1, C2, or the entire value chain of claims, was the liability. So the change then said, no, we are leaving claims, claims in verification and validation, claims in registration, claims in merits assessment, claims in quantum determination, claims in litigation. All these claims, as long as there is no offer on them yet, they were then left out of the financial statements. So in short, and in terms of a diagram, that's the flow in terms of the claims value chain, which, as I said, the gentleman in the first week explained well. And in terms of the liability, it's then that red arrow which labels the IPSAS liability and the IFRS 4. And I think just to tie it to 53 of the affidavit, of the same affidavit, it then just has a small table which says on the left-hand side, under the old Accounting Standards Board policy, which was based on IFRS 4, the provisions, the liability provisions that were included were the following categories. The first one, claims in transit, IBNR. The second one, under ORC. So,
okay, can I ask you to just skip that, because I think I'm thinking about time. My apologies. Basically, it's a tabular representation of what you showed in the diagram. So I think the members can see.
Right.
Thank you.
Yes, and then lastly, 54. It then just shows the actual amounts. It just shows that then, as at 31 March 2021, the entire claims liability based on the old accounting policy would have been 356.1 billion, with 341.2 billion being IBNR and ORC, and then 14.9 billion being RNYP. But then due to the change in accounting policy on 31 March 2021, the 356 billion, then only 29.6 billion then made it to the financial statement. And the understatement that Mr. Songelwa mentioned would then have been 326.5 billion on that date. And then again, under that table is just the acronyms. So yeah, I think that's my input on that part.
Sorry, you'll come to the next part, but I just want to ask this. So as I understand, there is an environment unique to the Road Accident Fund, where a claim claim liability is triggered the moment an accident happens, because any of those people except the one at fault may claim, right? But let us take that category out and use again another state entity or any commercial entity. If an entity removed a known potential liability from the financial statements, would those financial statements be an honest expression of the organization's financials?
If I may respond, definitely not. And which is in fact, that would lead to a qualification by the auditor. in the case of a private sector, for example, external auditors would definitely qualify because you have understated, or the entity has understated its liabilities. And that information that is put in the financials by the entity, if it understates their liabilities, is then misleading the public. And the danger to that, for example, is that if an entity was to raise funding using that information, the banks or the funders would come and say, we've been misled, for us to advance the thing. So to answer you, the understatement of fair liability is not accepted in accounting circles. Thank you.
Okay, not just at the road accident fund, as a general accounting practice.
Yes, Chair, 100%.
Okay, all right, thank you. So you do say in both of your in your submissions, and let me ask this: why was all of this necessary? In your understanding, why all of this change?
I struggled initially to say why would the Road Accident Fund want to make changes in its liabilities, because whether the figure is R1 trillion or R1, for example, we're a public entity. We're not going to use the financials to raise funding. If anything, it is critically important that we show the true state of affairs, so that the decision makers, be it National Treasury, Department of Transport, RAF boards, and decision makers can see the true state of affairs and financial thing. The only thing I think would have happened is that, so in 2021, there was a good thinking, though I must say, because the sheriff had a tendency of coming to RAF and take the assets, attach the banks. So the thinking was, where could we get the money to settle all the RNYP and then instead deal with the funder? So there was something called debt structuring that was put into the APP. And the amount that would be raised was in the tune of between 15 billion and 20 billion, because that's where the RNYP was at. So I think one of the things...
Was it debt structuring or debt restructuring? I saw debt restructuring in the annual report. I'm still coming to that second part, Mr. Charakupa. I haven't forgotten.
The correct term, it was a debt restructuring. Debt restructuring in the sense that you borrow funds from a financier, be it a bank, or whoever is financing. Debt restructuring, so you are substituting RNYP with a loan, for example. So you settle the RNYP, but you still have a debt that you need to service, because that debt would not be free money and it would attract interest, etc. And the thinking there was that if you raise a loan, perhaps the interest would be less than the interest you are paying on the RNYP, for example. That was the thinking. So to answer you, so one would need good financials to present to a bank to raise funding. Thank you.
Okay, let me ask. I mean, I understand debt restructuring, and I've seen this term in the annual report at the time. Debt restructuring, in my understanding, is a different thing. In other words, you already have debt on your books. You then approach the banks to renegotiate the terms of that loan. It might be bondholders. You go to them, the bond matures in 3 years. You go to them, you say, can it please mature in 5 years, etc., etc. Isn't that what debt restructuring is?
It is, but so the RNYP as a rough short-term liability was also treated that on its own, it is a debt to the entity. In other words, the RNYP is a debt to RAF, what's a liability really. So because you want to settle it or exchange it for a loan, hence debt restructuring. So we are restructuring this RNYP. Instead of it being RNYP, it becomes a loan with whatever the money has been raised from, if I may say.
Okay, no, thank you. So we last 3 questions and then we'll hand over to the members. So, Mr. Charakupa, so the second part of my question was, I see in the submission, and you can take us to that part of the affidavit, that the Road Accident Fund, as a result of all of this nyaga-nyaga that we were talking about, the number of claims that actually now make it through the door has dropped from the hundreds of thousands to initially just over 100,000, and then they dropped below 100,000. And I think in the 2023-2024 financial year, it was just over 63,000, right? And yet, so can you just tell us about the inefficiency? Because the amount of money that the RAF pays for the fewer claims does not drop. It goes up, right? Can you then tell us why it is that the Road Accident Fund would process and finalize and pay far fewer claims but continue to pay the same amount of money? Why would that be? They should have lots of money in the bank.
Yeah, sorry. Thank you, Chair. Yes, so I think I will start, I will go through it in 2 steps, let me say. I will start on point 82, or paragraph 82 in the affidavit. So there, what's there is a graph which shows rough personalized claims, finalized claims.
Sorry, which paragraph? 80?
82.
82, paragraph 82. Okay, thank you.
Yes.
That's on page
26.
26. All right.
And I wanted to look at this in side by side with, I think there's 2 pages that were printed.
Okay, so the members have them.
Yeah, I don't know if they were.
Which, these pages?
Yeah, those ones. There's
Okay,
2.
members.
There's 2 of them, yeah. Those 2.
The page looks like this. So this one.
Chair, sorry, if I can just ask you, Mr. Charakupa's affidavit in the file, I'm going through the file, I can't find it.
It's just that this affidavit's not in the file.
No, it's on email. Okay. Okay, can you just ask Lungisa to print it in any case, in any event? Because, okay, I actually thought it's in the bundle. I just look on the email and not on the... Okay, do any of the members have access to their emails right now? Who doesn't? So let's just get Lungisa to print it, please. Mr. Charakupa's affidavit, it was emailed. Is it printed? No, that is a supplementary. It makes corrections on the initial affidavit. I don't understand why it wasn't printed though. Sorry? It doesn't open. Okay, this is very important. So can we just hold here? So can we just, please, because the members are going to be affected now, I think. Okay. Okay. Can we do this? So instead of taking the break later so that we don't waste time, it's very important that the members have access to all the documents. So can we take is it okay if we take our 15-minute break now and then we will continue? Yeah, please. So the time is 11:03. We'll come back at 15:20 past. Sorry, honorable members, I apologize for this. I thought this had been provided. Sorry, Mr. Charakupa. So we're going to take a break now. Then we'll do a marathon until 1 o'clock. All right, thank you. Charakupa, you were showing us paragraph number 82. So just for the benefit of the members, for your later reading, the previous time Mr. Charakupa had shown us a sketch was in paragraph 52, I think. Yeah, so just mark there that it was on paragraph 52. During question time, you may want to return to it. So let's go to then, it's paragraph 82. All right, thank you.
Okay, thank you, Chair. So on 82 is personal claim files which were finalized for the period 2020 to 2024, right? So
Sorry, can I just ask you, I know it is dealt somewhere in your affidavit, but
Yes.
why does it say personal claims specifically rather than claims?
right. So there is two category of claims. There is supplier claims and there is personal claims. So your supplier claims are claims for largely service providers. Then personal claims are the people, your real victims of road accident. And I will tie paragraph 82 with the annual report page at 30. I think there's two pages that were given. There's one that looks like this. This is page 30 of the 2023-2024 annual report. Yes, you have this. Yeah, so this page is very, very important in terms of the number of claims that are processed at the Road Accident Fund. Right. So I add this page. So if you look at the table there, at the top is the very first line is registered claims.
Sorry, Mr. Charakupa, Honorable Madlala. Are you? Oh, I thought you need. Okay, no. I now freak out easily with documents that are in. Sorry, Mr. Charakupa.
All right. So page 30. This page is from page 30 of the rough annual report 2023-2024. Right. There is two sections in the table. The top one is registered claims, and it starts with personal claims and supplier claims. Then it shows that in 2024, in terms of registered claims, it was 79,377. And if you follow that line through at the end, the last column shows that as of 31 March 2020, for the year which ended 31 March 2020, the RIF had registered 303,695 claims. So in terms of registrations, your claims dropped from 303,695, which is the last column, to 79,377 in the 23-24 financial year. Right, that's the total line. But the more important one, which is the personal line, is right below that, the personal claims. So your personal claims, you will see that for the year ended 31 March 2020, what was registered was 102,086. It dropped, and then for the year ending 31 March 2021, that number was 51,306. And then it continued to drop. And for the year ending 31 March 2024, that number of claims registered from the year that started on 1 April 2023 and ended on 31 March 2024, only 18,286 claims were registered. So it dropped from 102,086 down to 18,000 for the year ending 31 March 2024. So that second line of personal claims on registration is the one that's on paragraph 83 on page 27. So on page 27, and then I will go back to 82, because now I'm doing the order of the table. So the order of the table starts with registrations at the top, then the second half will be finalized. But let me finish with registrations, then I'm going back to the finalizations. So on page 27, we can see there is a graph that shows in 2020, the big bar there is 102,086 claims. That's taking straight from this page of the annual report. And then in 2024, that number drops to 18,256 claims the whole year. And inside the first pillar there, I labeled 1,963 claims per week. That just shows that if you look at the 102,086 and you divide it by 52 weeks in a year, you would see that the RIF was registering 1,963 claims each week. But in 2024, the RIF was registering only 351 claims per week. So a drop from 1,000, almost 2,000, to a mere 351 claims per week. So that's the drop in terms of the rate of claims being processed each week. That's on page 27. And then if I go then back to page 26, and then I look at the table. So I keep tying it to this table because for members, for the benefit of members, all the annual reports have this page. And this page talks directly to the RIF claims database. So if there's any important page that you need to refer to year in, year out, in terms of the productivity and the activity on claims, is this page. If you take the annual report and you have to look for 2 pages, it's this page and the other one, but the other one talks to cost. So we're going to get to the cost page later, but this talks to the claims, the work done. And for personal claims, you then look at this line that I am showing you and these related graphs. So what happened to finalizations? Finalizations, on back to paragraph 82. The first bar shows that in 2020, 80,370 personal claims were finalized. That number dropped over the years. In 2021, that number dropped by 50,480. And only 27,890 claims were finalized during the 2021 financial year. There was a slight recovery in the 2022 financial year. 41,149 claims were finalized that. But again, if we compare it with the productivity level of 2020 of 80,370, 2022 is a drop of 39,221 claims. And then 2023, there was a further drop to 37,678 the entire year. Then 2024, the drop continued. So in 2024, only 26,808 claims were dropped. So if we just compare the all-time high...
You mean we finalized? You said 26 were dropped. 26,000. Did you mean finalized?
Finalized. Yeah, so 26,808 were finalized or settled. The drop was 53,562. Thank you for the correction. So it means that if you just compare 2020 and 2024, the drop was from 80,000, about 80,000 a year, to about 26,000 a year. In terms of per week, again in the bar there, in the first pillar, I show that 2020, there were 1,545 claims being finalized each week. And that dropped to about 515,000 per week in 2024. So more than 1,000 claims which could have been finalized if the RIF had adequate capacity were not finalized in 2024. So that's the drop in the productivity. And here I focused on personal claims because as I clarified, supplier claims are the service provider ones. They are important, but more important is your people, which is your personal claims. So that's the drop. And I think this the second part of my explanation then goes to the reasons for the drop. So I will go to paragraph.
Sorry, may I ask, are you going to return to the money?
Yes.
Okay, thank you.
So after I cover
No, that's fine. I just wanted to be sure. Thanks.
I'll get to the money. Right. So then we go to, so the money is page 33 of the annual report of those 2 pages. So we'll come back to it. I said I'm going to 97. So 97 of the affidavit on page 31, right? The label there at the top is RAF's new operational model. So RAF leadership implemented a new operating model, NOM, for claims from the year 2020-2021 onwards. Then 98, I won't read every line. The new operating model involved centralizing claims processing, reducing reliance on external attorneys, mainly referencing the panel of attorneys, the contracts that were terminated in June 2020, and then started using the state attorney office, attorneys that were located at the state attorney's office for claims processing. So that's the main change in the operational model there. And on 99, I think, yes, at 99, I'm referencing VS 18. So if you go to the big file, VS 18 is an annexure. It's an annexure. Right. So it's yes. So then it's an annexure from page 1. I think it is page 1 to 19, but I'll just cover high level. So at the bottom is the history of volumes, the historical volumes in terms of claims processed. So it's the history of productivity, right? It shows 2019-2020. In terms of the average there, the average was 243,958 per year. It was almost 244,000 per year, 2019-2020. Then under the new operating model, that dropped to 103,494 claims. So from 244,000 to about 103,000. And then again on page 2 of VS 18 is a graph just showing that drop in average. Again, we are just saying the table shows that the number of claims settled per year decreased by more than 58%, decreasing from an average of 243 to 103. Then point number 3 there is factors impacting productivity and operational efficiencies, right? So at that time, as part of our research, we engaged our then colleagues in the operations department, and in particular those departments, your claims registrations units, verifications and validations, merits assessment, litigation management, undertakings, post and post-settlement, and generally all the regional offices in the operations department, the management thereof. And the key factors that were then identified at that point was the reduction in staffing levels of the operations claims unit departments, and the termination of the RIF's panel of attorneys services in June of 2020. So in 3.1, which is page 3 of that's annexure, 3.1, what was highlighted was the understaffing and file count overload. So claim officers raised the challenge that their departments were understaffed, and each one of them had on average more than 2,000 claim files assigned for them to work on. On top of the files that they were expected to manage, they had to attend court sessions and consult with plaintiff attorneys in the office. That's the point 1. 3.1.2, the suspension and dismissal of employees. So during the 2021 and 22 financial years, more than 200 claim officers were suspended with the intention to dismiss them. Most of them were not replaced, which worsened the capacity challenges that were facing the department even before the suspension of the employees. This led to an increase in the claims backload, as claims were now being processed by fewer claim handlers that were remaining at the fund. So that's 3.1 is talking to the staffing challenge. Then 3.2 is talking to the termination of the RAF's panel of attorneys services. So the fund relied on a panel of attorneys to assist it with litigation processes involved in settlement of claims until June 2022. The RAF then terminated services of the panel in June 2022 and called for the immediate return of claim files that were in their possession. The panel was replaced by a small number of attorneys from the Office of the State Attorney who could not handle the workload and the volume of claims, creating a bottleneck in claims assessment process value chain. Based on information gathered from various stakeholders at the time, the RAF panel of attorneys consisted of attorney firms in excess of 100 at the time. And when the panel of attorneys was disbanded in 2020, each firm had a minimum of 5 or more attorneys in their employment. So that's about 500, 100 times 5, about 500 people assisting with the process. But that's on the low side, according to the input then. Then what these attorneys would assist the RAF the RAF with is the first bullet is attending to the litigation process. The second bullet is investigating matters and providing claim handlers with motivations on experts to be appointed. Then they attended to settlement negotiations. Where claims were found to have no merits or where the amount claimed was overstated, panel attorneys would assist to ensure that a proper case was made out before a judge on trial by ensuring that proper preparation for trial was attended to by appointing counsel and ensuring that the presence of witnesses to testify on behalf of the fund at the court. Then the last point there is upon finalization of a matter, the attorneys would also instruct cost consultants to similarly settle party and party bills of cost or attend the taxation thereof, thereby representing the interest of the RIAF. And then the last point is then just wrapping up to say, with the termination of the panel and the demand for files on litigated matters to be immediately returned to the fund, the benefits of inputs by counsel, the presentation of proper evidence in court to the benefit of the RIAF was abandoned. The RAF was left without representation for a long time. The vast majority of trial matters enrolled for trial from June 2022 were finalized in court without any legal representation on behalf of the RIAF. Less than 20 attorneys during the 2021 financial year were available to try and fill the capacity void created by the termination of the panel of attorneys.
Sorry, Mr. Charakupa, are you going to read the entire document? I'm not saying this in a bad way, but I am concerned for time. So the members can read, but if you can narrate, I think that would be helpful.
Yes. So I think that was wrapping up on page 4, the top part. So on the productivity aspect, on the number of claims that were settled, which is what we just looked at now in terms of bullet 82, the drop from 80,370 per year to 26,808. The drivers for that, or the reasons for that, are captured in that document, and I just highlighted that. So I will stop there in terms of 82. Similarly, 83 though. So I think I will just cover 83, the one on 83, the registrations. It's capacity issues. But with 83, in addition to the capacity issues, was the new RAF 1 form, and yes, the new RAF 1 form, and also on both of them, the other issue is then the direct claims, the discontinuation of direct claims department. So that's why we dropped from, in terms of finalizations, the 1,500 per week to 515 per week in 2024. And in terms of registrations, the drop from 1,963 to 351 per week. So I have talked to the number of claims and the factors therefore. And then I will go to the cost part, but I will pause here before I go to the cost part.
No, please go to the cost part, because that was my question. And if I may, just summarize those costs the members have on page 4 and 5 of that report. Let me just ask you, this report was prepared for the Road Accident Fund?
The one on PS 16.
Yes, that annex was prepared for the Road Accident Fund?
Yes, back then in 2021, 2022.
So in 2021, 2022, this information was available to the management, and do you know if this was sent to the board at all? The information was available to management, and even in terms of presentation of funding model and MTF, which was an annual engagement. This is the discussion that we had at EXCO at that time. So in terms of the presentation to the board, though, I wouldn't know, because our engagement with my boss at that point would end at EXCO. That's fine. We'll ask the EXCO and board. Let me ask, so were you in the discussion at EXCO about this report?
About the funding model. So if you look at the report,
no. I mean, this one that you've just read to us.
So this report fed into the funding model MTF discussion, where these issues were discussed.
That's fine. My question is, were you in that discussion?
Yes, the June 2022.
What was the view there? I mean, if I look at these kind of numbers, I am going to have a concern that people are waiting for their claims. They don't get finalized, right? So they're going to wait for years. And I see that in one of the graphs, the number of outstanding claims actually shoots up to over 350,000, I think, by 2023, 2024, right? So that's one. So before we get to the money, was anyone alarmed by this? How was this information received in that discussion?
So in that discussion, our focus though was more on the money. The operations, the acting operations chief executive at that point raised the issue on the numbers and the capacity, and the capacity both on staff and on panel. So I am not sure then what the feedback on the aspect of capacity was. But yes, this was evident to everyone, because these numbers, in terms of monthly reports, quarterly reports, and then this is the annual review. So this is the annual report. We're pretty evident.
Okay, let me ask, just switch off your mic. So let me ask, so was there, subsequent to that, and maybe Mr. Songelwa, you would know, was there any discussion or attempt to recapacitate some of the areas where this report indicates that due to lack of capacity? I mean, the attorneys we know about, but it appears that there was also internal capacity issues. Was there an effort to then recapacitate the area so that they can process the claims, because the outstanding claims were accumulating?
I think on the state attorneys, for example, the idea was that the state attorneys would be fully capacitated to take care of the gap left by the panel of attorneys, for example. My understanding is that the capacity was never enough for the state attorneys. The other thing that came in that would assist would be the ICMS, Integrated Claims Management System, where some of the functions would be automated. I think we heard recently that the ICMS is actually a challenge as we stand. So to answer you, brilliant ideas, but for some reason they didn't really pick up nicely, so to speak.
Were more people hired, as far as you know? So in other words, there are all of these problems. We can see that as a result of people being on suspension with intention to dismiss. I'm not sure what that means, but absent of a hearing, we can deal with it at another time. But basically, there were warm bodies. If I look at there were warm bodies that are now no longer there. To your knowledge, and if you don't know, it's fine. To your knowledge, was there an attempt to hire more people, even if it's on a temporary basis, to make sure that these claims, that these productivity levels can then go up again?
Since, thank you, Shane. Since this is an operational item, I would not know the numbers. I think we're at regional level and the operations level at head office, I wouldn't. I'm sure RAF would be able to respond to that question. Thank you.
Okay. No, thank you very much. Can we go to the cost? Because I want us to wrap up and at least have the last hour to the members.
Thank you, Chair. So on the costs, again, I will start from the annual report page. So that's the other page attached. It's page 33. It's page 33. At the top, it's written Road Accident Fund 2023-2024 annual report. But I will start by ending at 2022. Then we can talk about 2023 and 2024 later. Right. So on that table, if you look at the third column from the end, which is 31 March 2020, the third column from the end. The top number there is 44, then 000. That number is 44 billion, right? And below that number is 138,010. And then below that number is 318,576. So those three lines, I will just focus on those three. The other ones are breakdowns. I will not focus on that for now. So the top line is just showing the amount of money that was paid for all claims. So it's just showing that in 2020, 44 billion was paid. In 2021, 35.5 billion was paid. In 2022, 43.4 billion was paid. Then the year ending 31 March 2023, 46.4 billion was paid. Then the year ending 31 March 2024, 45.6 billion was paid. Right. So now the 2020 financial year, the important number that I would then draw you attention on is that second line, which is the 138,010. So that shows that the average value of a rough claim for the year 2020 all the 318,000 claims that were paid there. Those were the payments. The average value was 138,000. Then come 2021, 31 March 2021.
Yeah, just take us to the end there. I just worry for time if we go through each one. So the members are looking at it. So we started 138,000.
Right. And then
claim, and we end up where?
In 235,141. No, March 2021. That one is important. I need to emphasize 2020 to 2021 first.
Right.
Yes. So that jump there in average cost is 70%. So that's inflation in 1 year. So 1 year, inflation jumped by 70%. And as you would know...
Okay, so when you say inflation, to people watching at home, they will think of the governor of the Reserve Bank and the repo rate. So can you please use a simpler term to explain what you mean?
So it ties to that because Stats SA, remember, issues the inflation figure of, let's say, 5% each year, right? Now that's the increase in the cost of living. Whatever you buy from the shops, your bread, your transport cost, your bread, your basket, your grocery, your monthly grocery, year in, year out, it increases. The cost of that increases. So it increases in line with inflation. So it increases around, the 6%, usually below. The governor of the Reserve Bank tried to target that, in the 4 to 6%. So that's what you would also, even salaries, they increase along the lines of inflation. Or medical expenses, I think they're the ones that increase the highest, which is maybe CPI plus 2%. So generally, most things increase by less than 10% in any given year.
So I appreciate that, Ms. Charakupa. So what you're trying to say to us is that if we look at the years 2018 to 2020 and you look at the average value per claim,
yes,
it is in line generally with the rate of inflation.
Yes.
And then from 2020 to 2021, you're not even talking inflation, you're talking an astronomical
increase.
Yes. In the average payout per claim.
Yes.
And then
I think page 7, so that's just showing that on page 7 of VS 18. So if you just go to page 7 of that, I show that graph there. Page 7 of that report we were going through. So graphically, it's just showing there that it increased. So normally what would then happen in 20, so it shows the 235 there, the red line is the jump, and the green line is the increase you would expect in line with inflation. So the 70% increase is just a huge increase by any margin.
So what causes that?
So what caused that are exactly the same factors which we were looking at. The discontinuation of the panel of attorneys and the understaffing, because that led to inflated claim settlements and default judgments. So the combination of inflated claim settlements and default judgment led to this 70% increase in the cost of a single claim, right? So then typically what would happen is the management and the board at that time would then look at that 70%. I mean, these things happen once in a while, even in insurance business. There can be a spike in your cost or in your severity. But immediately, the board and management need to sit down and look at the drivers of that spike and implement measures to then reduce that spike in the cost of doing business, cost of settlement. But we can see there on page 7 that did not happen from 235, it actually got worse, 2021, 2022. It increased to 254,531. So nothing was done. I mean, from a finance perspective, this is now us looking at the numbers and say, was something done to correct this? Then we can see that nothing was done, or whatever was done did not work to address the problem. So the underlying challenges in terms of capacity are not addressed as at end of March 2022, 31 March 2022. And to close that, I will then just go to paragraph. So this is then, but now I think I'll go to paragraph. Let me just close that aspect. Page 41, paragraph 123, but the graph is on page 41. So when we then use these numbers in terms of the annual report 2023-2024, you can see that red line, that even up until the end of 2023-2024, that spike continued unaddressed. So the message you get there, even if you are sitting outside, is the underlying operational issues are still unaddressed. I will pause there, Chair. Or, Mr. Songelwa, you can add, yeah.
I think you've covered it all at the time. I think, as he says, the default judgments increased the average per claim, as he has said, really. And
All right. No, thank you very much. I'm going to ask one final issue. So basically, there are changes in the management structures then. With the arrival of various specialists, it would appear from the affidavit that the one that had the most impact on this piece of work was the chief investment officer, General Mancho, basically initially specialist acting throughout until acting chief investment officer, which remains the incumbent right now. And I am not certain which paragraph it is, but there is a point when some of the information. So can you just tell us about the role of the chief investment officer in this universe, right? And some of the changes in practice and the changes in outcome that resulted from that, and then we'll go to the members.
thank you, Chair. I will take that. There will be paragraph 31 of my affidavit or my statement. Paragraph 31. What then happened is that the acting CEO appointed several specialists in his office. The first batch, 31.1. The first batch of the specialists arrived on the 4th of May 2020. It was the senior finance specialist, I will leave the name, treasury specialist, and change specialist. That is the first batch on the 4th of May 2021. The second batch came on the 1st of June 2020. It was the communication specialist and the senior change specialist. Another specialist arrived on the 1st of July in the position of re-engineering specialist. And then in addition, there was also specialist ICT and specialist security. Those were the people that came in as advisors or specialists in the office of the CEO. The question was...
Sorry, can I ask?
Yes.
Can I ask? Please switch off the mic. Were any of these roles advertised, as far as you can recall?
Thank you. As far as I can recall, these positions were not advertised, but the people that came in as a specialist, as advisors in the office of the CEO. If they were advertised, I think that some people at the RAF would have had an interest in applying, for example. They would have an opportunity. So, to my understanding or knowledge, they were not advertised at the RAF. Thank you. But then the question was more on the acting CIO. So, as I said, on the 4th of May 2020 comes treasury specialist comes on the 4th of May. In June, okay, there's a link between the two. The senior finance specialist as well that came on the 4th of May. becomes the acting CFO from the 2nd of June 2020. And in July 2020, the Treasury Specialist becomes an acting General Manager, Treasury. I want to emphasize this. And there was no position in the organizational structure of the RAF for the Treasury Specialist. If anything, we had a Senior Manager, Treasury, that was falling under the General Manager, Finance. So then this position, without it being on the structure, was then taken over by the Treasury Specialist. And then later on, as I said, the Treasury Specialist... Yes.
Sorry, Mr. Songelwa, so what happened to the person who had then been in that role?
So what we had in the Treasury was headed by a Senior Manager. The Senior Manager remained there. There was an actor there, acting as Senior Manager, because the other person was there, had left for better opportunities, and she's doing very well where she left. And then the person was acting in that position. So the expectation would be, if anything, would be to fill in the position of the Senior Manager, Treasury. But instead, you've got the Senior Manager, Treasury, acting, and then a new position is created called the General Manager, Treasury. And general managers normally have portfolios like about 3 or 4. In this case, it was only General Manager for Treasury. That was, in my opinion, abnormal in that, as I say, it was not in the structure. I did inquire at HR whether do we have a job profile for this position, and the answer was it was not there. So to answer you, your question, what happened to the position it was never there. We took the Treasury Specialist to become the General Manager, Treasury, which was not in the structure. Then later on, the acting General Manager, Treasury, when there was a restructuring, organizational structure review, in 2022, the same person that had come in as a specialist or advisor in the office of the CEO became the acting Chief Investment Officer. And again, this one was in the new structure, acting. There's some questions in it whether it was rough at the right stage to have even Chief Investment Officer, considering that the liabilities of the entity exceed assets, for example. And that's a question for another day, if I may say. But I think I've answered in terms of the journey of the person that came in as a Treasury Specialist and ended up being an acting Chief Investment Officer. I'll leave it there, Chair. Or maybe I might...
Yeah, I was going to say then,
yes,
because the question initially was then how does this relationship then affect the work around these issues, or at least how you used to proceed and do the work, because there is this new role. And I note in the affidavit, I just don't want us to do chapter and verse of it, but I note that there were instances where this person did not want certain things done, didn't want certain reports to be generated, etc., etc. So I just want to understand that universe, and then we'll go to the members. So both of you can speak to that.
Let me continue then, Chair. Thank you for that, actually. Then what actually happened then, I did not want to come to this because it's personal, but now that you mentioned it, so as a general manager, I had 5 portfolios. I joined RAF on the 1st of October 2015. The first portfolio was actuarial department, headed by senior manager in the name of Itai Charakupa. The second portfolio would be treasury. I'm not putting them in their importance, I'm just randomly saying them, so my colleagues should still feel that I said who comes first, was treasury, headed by senior manager as well. The other, there was 5 of them. The other one was financial accounting, all they headed by senior managers. The other one was financial reporting, and then lastly was management accounting, which is responsible for budgeting. So what has happened now, I've said already, the treasury specialist had taken over the position of the treasury. So I was left with 4 portfolios, and then the actuarial was reporting to me. They would do the claims valuation processes that would present to the governance structure, audit committee, risk, governance, and actuarial committee up to the board for approval. When the treasury specialist was appointed as the general manager treasury, who later became a chief investment officer. There was a move, not a move, he somehow took over the actuarial department. I found him giving instructions to the team in actuarial. And you asked about this report at that point. For example, when they present report, get a report back that when these things, for example, there's increases in the claims, average claim cost, the reaction would be, you guys are negative, you're giving us negative information. I'm saying that I didn't hear it, but there was a report I would get from the team. And then I could see that there's some pressure on them to a point that, as I said, later on, when there was a change in accounting policy, the claims valuation.
Sorry, let me ask.
Sure.
Was there a formal decision to change your portfolio that was communicated to you?
No, Chair. It's a very interesting question. And we had a classic example within actuarial. We had another function within actuarial for reinsurance. The reinsurance was moved to risk with the new structure coming in. When that person or that unit or function was moved from actuarial to risk department, a formal there was a workshop, a memo that was done, executive summary that was done for the move of this person. We had a nice handover. Person is leaving my department, actuarial, to another department. However, when the acting chief investment officer started giving instructions to the team in actuarial, there was no formal transfer for the people from my department to the investment department. And this is very important because they needed some labor related issues in it. In terms of structurally, the team is reporting to me because there's no formal transfer, yet the instructions are coming from elsewhere, to a point of, I'm not making this a defense thing, to a point of when there are some disciplinary actions to be taken, they would be taken without my knowledge, for example.
Okay. No, thank you. So thank you very much for that. That's very important context, because we had the security department giving a similar account of the security specialist there, which we will canvass again at a different hearing when we get the relevant people to come here. So the same pattern appears to have occurred here. So I mean, is there anything you want to add, Mr. Charakupa? You done, Mr. Songelwa, and is there anything you want to add? Because I do want to hand over to the members. They will ask questions that are on any of the documents, including your affidavits, in any event. But what I really needed to understand is with all of these changes, one of the things we'll be assessing is the level of the quality of the board's oversight over all of this, and whether some of these concerns were dealt with adequately and so on. So I just want to know if there's anything that you feel is important for our purposes here, where you've got an opinion on value leakage for the road accident fund, the efficiency of operations, and the impact on claimants and other stakeholders and so on. I just want us to wrap it up for now along those lines.
My comment would be, I feel strongly that for the people to come in as specialists or advisors, and then they end up occupying executive position, it poses a risk, because when you're appointed, you go through the process of vetting, for example, and then somebody is coming as an advisor, and I'm just saying this from a governance point of view. You come in as an advisor or specialist in the office of the CEO, next thing you occupy an executive position that has got too much weight. Who knows if you're vetted or not vetted? We do not know. So personally, I would recommend that something be done in the entity to check whether I'm missing it, where the positions advertised, was a fair recruitment process followed for those individuals. And I'm not being personal, I'm just saying from a governance point of view. And thank you so much, a high level.
Thank you. I think he has covered it well. I think part of your question was on the operations side. There was a acting chief operations officer up until 2022. And my understanding in terms of our engagements with regional offices, when they'd raised staffing issues, all these challenges with staff, with lack of capacity after the panel, I think she had at some point motivated for that. And I would assume that, all those motivations and the responses thereof would then be available. So I think when you engage the executives on the side of operations, I think they will be able to answer to that more accurately. Thanks.
All right. Thank you very much. I think let me leave it here for now. I will come back at the end or ask clarification questions in between if there's anything that we want to. So, honorable members, can I then hand over to you? So yesterday I started on my left. I'm going to start on my right, to be fair. Otherwise, I'm going to have like Honorable Isaac saying I'm not his favorite. So, Honorable Mende, can we work on, because we're going to have a second bite in it, can we work on 15 minutes? If that's okay. We'll just continue when we come back from the House. Oh, are you not ready?
No, thank you, Chair. No, I wanted to establish two things before, because we got a 3-hour lecture and a pile of documents that we must deal with, and the information we've processed it. My worry now is that if we're starting now at 12:20 and the House is sitting at 3, I'm a whip for a week. I must leave here at 1 to go process House business. And I don't think this is going to now disadvantage us. Already with the information plus additional information that we are getting now when it's clarified, it has already given me more than 30 questions in many aspects or areas of their capacity at RAF. So, Chair, I don't know what must happen. I think I'm going to advise that we did not go through documentation and submissions in terms of who must come here on what basis and what clarities do we seek. We're only here when they arrive and when you lead on what must happen. But here to say 15 minutes, I don't think that's sufficient.
That's fine. So what time do you think would be sufficient, Honorable Mende? Because I want us to have a complete conversation.
At least
also
20 minutes at most.
Okay. So firstly, the intention is to break at 1, right? So the intention is to break at 1, so that members who have got other responsibilities relating to the House can go and carry out those responsibilities. So we will break at 1, first of all. The second thing is I just want to ask members, do you have a difficulty with the suggestion of 20 minutes? Not. Honorable Skosan?
Yeah, Chair. I thought you were saying that maybe we would get a second opportunity. So in that view, I think 15 minutes was going to be fine. But then maybe after, we might also give the other 5 minutes if members still have follow-up questions. Maybe let's start with the 15 minutes with a view that we might get the second round after the House for 5 minutes each if we've got the additional question. And noting that we have not started at 9 o'clock, we've started almost at 10. Can't we push it till 1:30 maybe?
So Honorable Skosana, so we are not going to be able to accommodate everyone, even if we finish at 1:30, even with 15 minutes. So when we come back from the House, it will be a continuation, right? Because so when you come back from the House, it won't be round 2 for everyone. Everyone will still be on round 1. Okay, so that's why I'm look, here's what's available, honorable members. If a member does not want to take up the entire 20 minutes, we then get to save time. Right? I understand the matters are fairly complex, but at the same time important. So I don't personally have a difficulty with 20 minutes, but Honorable Skosana is saying let's stay on 15 minutes. Honorable Mende says let's do 20 minutes. So I then need to put it to the members.
Chair, I support the 20 minutes.
Okay. May I persuade you, Honorable Skosana, that we stick to 20? You'll get 20 minutes.
Yeah, no, I accept. I withdraw the 15.
Okay. All right. Honorable Mende, 20 minutes.
No, thank you very much, Chair. Good afternoon to everyone. Mr. Songelwa and Mr. Charakupa. Am I correct to say you are both no longer at RAF? Just confirmation.
Got to say it in the mic so that it can. Yeah.
Yes, 100% correct for me. I left long thing. I left draft on the 17th of April this year. The contract was ending on 30 September this year, and it has ended. So to answer you, I am out of RAF now. Yes.
Because your contract ended.
Yes, my contract ended. That's the reason. Actually, it was there. I've been there for over 10 years.
Thank you. Yes, Mr. Charakupa.
Yes, you are correct. I left the RAF in April 2023, and I was dismissed by the acting chief investment officer.
Thank you. I will not ask why. We are not dealing with HR matters. HR matters will be dealt with by portfolio committee. Now, here is two components I want to uplift, and in particular, Mr. Songelwa, I need you to assist us here. The mandate of RAF, we all know what it is. The English, the crunching of numbers and everything else means absolutely nothing to a claimant who has never received their money. And our crunching of numbers should also be purported at achieving the goal of paying every claimant who's deserving. But that is what is at the center of this. At the center of this is that claimants are not being paid. People that are working at RAF, however, they get paid. There is no month where you are never paid, but claims are not getting out of the system. So at the center of what we're trying to do here, we're trying to find out why are the claimants not being paid. And that's it, it's clear like that. The second thing is, everyone who comes here seems to be sticking to the act. RAF Act says I must get this. RAF Act says I must do that. RAF Act says I must do this. You are equally arguing the standards of financial statements, submissions, and the change of standard thereof. I want to understand, was there at any point where the ASB indicated that you can use IPSAS 42?
Not to my knowledge, Honorable Mende.
You were at RAF until, from when until when?
From 1st October 2015 to 30th September 2025. Make it 17 April 2025.
Are you aware of the ASB letter of 2016? Excuse me, Chair, I'm operating from a laptop because I'm trying to be quick. So there's a letter dated year 2016 where ASB is indicating that the IPSAS 42 can be utilized. Are you aware of that?
I am not aware of that. Because if I was aware of that, then I would have to comply. There's no question about that. If ASB says do it, I definitely do it. I would not even argue because we've got a banking. Even if I feel that it would understate the liability, I would have to explain that in terms of the ASB standards, that this is the situation. My understanding was that ASB said they were developing the accounting standard around social benefits. As I say, currently, they have exposure draft 205. So I do not know that part at all.
Okay. You said this is the disadvantage of not knowing what we're dealing with. Because we have been dealing with this issue of the standards for quite a long time. And at some point, there was a mitigating factor, and ASP even came to Parliament to say, yeah, we are amenable into finding a suitable standard for the environment that you are working in. The letter is dated 13 July 2016. I'll send it to you, Chair, and so that they can have a benefit of seeing it. Now, let's leave that one. You have not seen it before. Let's go to the Act. Since you have been there and how the Act operates, this is in line with how you were reading to us the monies that are understated and what is due to the claimants. But I have a difficulty and the biggest problem with the Act itself. And please confirm to this committee, if the Act, in your own opinion, it is the Act, it's a law, you have to follow the law. There is nothing you can do. If the law is there, it is there. But when the law no longer serves the purpose, the law must change. And who must then propose the change in the law is the people that are implementing it, because you see that this particular law no longer serves the purpose in terms of what we're doing. Isn't that correct?
Correct, Honorable Member, 100%
Now,
correct.
thank you very much. Let's go to your law, the RAF Act. Under Section 18, in fact, from Section 17, RAF Act under Section 17 says the payments must be in lump sums. And being on lump sums, then it says under 18.4 for funerals. You die in an accident, it will pay after a funeral, but it will pay only the cremation or the burial. Do you agree with that?
In terms of the Act, yes, I agree that the Act.
Sorry, Mr. Songelwa. So, yeah, it's very important. Otherwise,
Sorry.
yeah.
Honorable Mende, as the Act says that, how do I put it? It is an unfair amount. It really, what does it even cover? However, if the Act says so, unfortunately, I've got to follow the Act and apply the law until we make an amendment to the Act. But to answer you, I just follow what the Act says. I disagree with the amount in terms of when was it done. Is it really enough? It is not enough. However, unfortunately, I've got to apply what the law says. Until we make, or the lawmakers make the changes to the law, then I would follow that one. Sorry.
Thank you. Then let's continue. Section 19 of the Act. 19C, it gives only the exclusivity to the use of lawyers as intermediaries. You earlier on spoke of the issue around direct claims. The law says exclusively use lawyers. Do you agree?
I respond? No, I never spoke of direct claims at all, because I'm in finance and I'm not running away from responsibility. I heard my colleagues when they were speaking about direct claims as far as RAF is concerned, but to answer you, I did not mention, even in my statement, I haven't mentioned the direct claims as an alternative. I do not have an opinion on that one because, as you say, Section 19C says that, and I have to follow that if that is what it says.
But do you agree that people must exclusively use lawyers even if they know how to fill the RAF 1 form and continue with their claim?
Which is why now you put them into another place. When I applied to join RAF, I joined them on the 1st of October 2015. My interview was done in June and July, 2 legs of it. One of my selling points was that at that stage they were talking of the Road Accident Benefit Scheme, RABS, which would do away with lawyers and people would claim direct. It would keep, I think we've heard about it. I don't want to get to that because I say Department of Transport level, not at my level. However, to answer you, I fully understood that people must have access to claiming directly in a very simplified form without any complications whatsoever. As when you become old, 60, you go to SASSA, ask for your old age grant. It's a very simple process. So the claiming from RIF should be as simple as that as well, so that anybody can do it easily to save cost without having to involve lawyers at all. I'm for that.
Yeah, that is C and D. I will not ask about D. You have answered it. Then again, there is another problematic area. It's just quite a few, Chair, that I've picked up. 24/5, the objection time frame. That if RAF doesn't object in 60 days, then the claim is valid in all respects of law. Now let's read that against what Mr. Charakupa was presenting here. The 300 and what claims of 2019? 303,695. Here you have 303,000 claims, 695. How many lawyers will you require as RAF to go and make sure that you object to unfair inflation of claims, people rejecting the offers of RAF and putting their own offer, subjecting it to court as summons? How many lawyers will you need in 60 days to make sure that you go to court and fight against those that are saying, no, we reject the offer of 303,695 claims? Or we can then say, assume maybe 100,000 of those people don't have a problem, but 200,000 of these people have a problem with your offer and they subjected to a court process. How many lawyers will you need?
Quite a huge number. I think I agree with you, Honorable Mandate, that the Act, as I say, in 2015, when I applied for job at RAF, one of the things I said, I'm happy that RAF Act will be changed, something new will come. I'm still of that view. I'm actually surprised that it took so long without changing this Act, because the Act as it stands is very, very unfriendly towards the claimant and towards the privileged disadvantaged, actually, to a point that I find it really not that thing. So I agree. It's impractical, some of things to apply. For example, we want to settle within 120 days. How fast would you do that? And you mentioned this part of 60 days as well. So there's a lot of items or sections in the RAF Act that are hard to implement, to a point of being impossible. Hence, the Act needs to be changed. So as I was encouraged for RABs, I know there's different views, I'm not going to get there. The CEO did say that, the former CEO rather, that there have been RAF Act amendment has been starting in the department. The DM spoke at length and the minister as to where the changes are. So I fully agree. RAF Act is a big problem. One of my challenges, maybe without that, one of my challenges with it, for example, is the payment of lump sums versus annuity. I am for the payment of annuities. You have seen the I blew it stories, etc., etc. So that Act is not like when I joined RAF, why don't we pay people installments? Because a longer time, they'll be fine. However, as you say, I've got a similar challenge with the RAF Act, and I don't say I don't like it. It needs to be amended as soon as possible. It was done in 1996. So much has changed now, and really so much has changed. My colleague Itai mentioned statistics that is very discouraging. It's precisely because of the challenges within the Act itself. So the Act needs to be revisited. I don't know if I forget better to say. Respectfully, I wanted to go back to SPM and correct something.
I'm not cutting you. Honorable Mende is also on a clock, so I do wanted to get through as many of her questions as possible. So I'm not cutting you off. So at a point when you've substantively answered a question, if she wants more, she will tell you that she.
May I please correct something? I want to go back before I forget it. I'm old. The ASP 2016 letter. You are saying that you are saying we can implement IPSAS 42.
I've closed it.
No, I'll just clarify you. So the IPSAS 42 came in 2019, first time ever. So in 2016, there would not have been a talk about the implementation of it. And besides, I remember, I think around 2016 was more of a discussion paper, white paper, by the Accounting Standards Board proposing how do we treat social benefits in the South African environment. So the EPSAS 42 would not have been an issue in 2016 at all. As I said, it was introduced in 2019, and it took, if I may say, 16 years to develop that standard by the international community. It's a big, big challenge even within them, but I'll leave it there. Sorry.
I did suspend the clock, Honorable Member, so you can you can continue.
Yeah. Thank you very much that you have clarified. Yes, RAF had started exploring means of accounting around the challenges of what is live and what is not live, because there are live transactions, but there are transactions that are just on the pipeline. And as an institution, you started working on how best you can account. So I just wanted to deal with the fact that the EPSAS 42 was not something that just came in 2019. It was somewhere there at RAF. Because there is a myth that things started going south in 2019. That's not true.
No, Honorable Member, I can stand on this one. I joined RAF in 2015, JM Finance, very involved in the development of the financial statements for the RAF, put on record. EPSAS 42 on its own was not there in 2016 at all, for the record, 100% sure about that one. If anything, it was a discussion paper on the social benefits in the South African context. It went on, and then EPSAS 42 came, which is an international accounting standard. We need a localized standard, will be GRAP something. For example, GRAP 19 is on provision. There's a corresponding statement for it in EPSAS. So to answer you, 2016, I'm 100% sure. And I know if I'm lying, it will cost me. But in 2016, in South Africa, EPSAS 42.
That's not an issue. We'll send you the letter. It also has the FSB that has had a directive in 2011, and FSB also features in the Act of RAF in terms of supervision. But we're not there. We'll get there.
Sorry, may I correct something? And please, maybe I'm not sure. Maybe it was there, but as far as I'm concerned, I don't think it was there. But it was just in case. I'm apologizing. I do not know about it.
No problem. There's nothing wrong with that. Thank you very much, sir. And you have answered the next question I was going to ask you. If you were a CEO faced with this kind of an act that does not work in your favor and does not suit the environment at all, what were you going to do? Because I'm going to add to that the necessity of the panel and keeping it, and at what cost, besides having to make proposals in terms of how do you work around the system in order for the system to work for the people, but not service providers. What were you going to do if you were a CEO? You are faced with such an act. You have service providers who are forcing themselves into the system because the act enables an environment to now serve service providers than the claimants. What are you going to do?
Actually, I think I would be camping to the lawmakers very regularly to show the seriousness of my wanting a change in the act. The RAF Act is not friendly. It's not good for the majority, for the previous disadvantage. So I would definitely, and I mean this, I would really do everything in my power to make sure that some changes are made. For example, that payment of lump sum versus annuity, it affects the financials of the RAF, liquidity, immediate solvency. So that would need to, can the lawmakers, without changing the whole thing, just address this quick one, the ones that we need to address. RABS was actually addressing that because there was a commission by Kathy Sechwell, judge, that came with the commission, recommendations were made, RABS came in. To me, it looked as a very good alternative to the RAF Act, for example. So to answer you out, definitely, 2015 is now 2025. There's absolutely no change whatsoever in the Act just to address some of these low-lying challenges. So I would have definitely made sure that I focus and it's done, at least. Minor changes. I remember in 2008 there was changes that were made where the maximum payment for public passengers was 25,000 rand. That was unfair. It was then changed. So I would have definitely done something. That act is not good. It's really, really causes this insolvency at RAF. It's just not a good act at all. So I would definitely, 10 years, 5 years is too much. I would really have made noise and a positive noise to change the act and lobby it to everything possible. Very, very serious. I want to touch on something as well, taking advantage. You mentioned the panel, for example. Much as the panel of attorneys was done away with, I'm now aware that there is a panel of attorneys for corporate. They've got different categories, commercial, labor-related issues, but there's one that caught my attention. This was approved, or the tender was made in 2023, panel of attorneys. There's a category there called personal injury. I know personal injury to address exactly the claims, and there's about 25 attorneys that are placed for that. My question is, are they being used? And if that's the case, I think it answers the question that the chair also raised in terms of were there any other things that were done to address what my colleague said in terms of these claims, averages going up, and like we are challenged, and the reduction in the number of claims. So there's a panel that I would like maybe when RAF could be asked to provide this committee with more details regarding the panel that was appointed in 2023 in November, because it then means that there's still, and I'm not advocating for panel of attorneys actually, I think my colleague John said as well, we like the insourcing. I'm old, it's a very good thing. I can take it further. I don't understand why the people that are doing cleaning services, the security are not fully employed to get the benefits and pension. But back to my story. So there is, in 2023, a panel of attorneys that does personal injuries. And my question was, but we said we're bringing the state attorneys, we should beef up or whatever, but that's a discussion for another day. So to answer you, what would I have done? I would definitely have lobbied to change the RAF Act. It needs to be. It's very, very, very wrong.
Honorable Member, let me give you two more questions. So, Mr. Songelwa, can you, I know you're passionate, and I worry about Honorable Mendes' time. So, can you just try and keep your answers concise, please?
No, thank you, Chair. And I was just getting to the second part because I wanted to deal with the issue of the legislation, because what enables the rot and the mess in RAF is the legislation. Is no one is doing anything about it. And yes, again, are you attributing that as a failure to us? It is. We failed RAF because we enabled an environment for people to treat it as a cash cow. Hence, you have to now crunch numbers and start blaming each other. You don't have to blame each other for anything. Your crunching of numbers is honest, but blaming each other is wrong because there is no one who did anything wrong at RAF. It's the law that is wrong. And in trying to correct the law, then you're trying to maneuver the system because, one, there was no need for the panel of attorneys. It is enabled by the 60-day that is in the law, and thinking that you are doing it, but then it's treated as something else. And once you stop it and insource the lawyers, then again there's an outcry. The second thing is, I want to get to the challenges before 2019. What are the challenges as were there? Because I know somewhere we were told of day zero at RAF. Before 2019, I'm going to clap them so that the chair doesn't call me. There was a day zero at RAF. What was that about? And why was it there? Then there was something about the letter of comfort at National Treasury and the Department of Transport to try and cushion some of the challenges. Then the legal cost, we can park the one of the legal cost because we've addressed it. And there's actuarial services that were stopped. And what was the cost of the actuarial services, and then what replaced the actuarial services. But most interestingly, in your submission, your term was going to end at some point, and then it was renewed. And then can you take us through who renewed your term of office, and what was the role of the current board and the executive, in particular the CEO, in your extension of the contract? Thank you, Chair.
Microphone.
Sorry, excuse me, thank you. Before 2019, day zero. Day zero was a question that came in one of the board meetings. Somebody said, didn't we have day zero in Cape Town for water, by the way? Yes. So day zero was, at what stage shall we say we can no longer pay any claims as RAF? Close shops. That's day zero. Money is finished. We cannot, the claims are now more than what we are getting. But I always say the RAF's advantage is that unlike the other entities, perhaps, RAF does not depend on bailouts or money coming from the state, like other entities that do great job, but they get allocated a certain funding by departments. RAF's at least income is guaranteed every month. Though it's not enough, that 218 cents per litre, you don't say government, every month we get about 4 billion on average at RAF. So it then became to a point that there'll really not be a day zero as such, because the only thing that will happen is that, and this is a problem, RAFs, the money that is coming into RAF in the form of fuel levy monthly is never enough. Is never enough to meet the expenditure. On average, when we settle claims and things working normally, I'm upset by the statistics now that we seem to be regressing. When the production is happening, service delivery is happening, the money is not an issue. In other words, pushing claims to come in. This is very important. Got RAF on the road, you got everything reaching all the places, people are submitting claims, and it's happening. What it does was, many years, 2019 around there, the settlements would be 4.5 billion per month. The money coming in would be 3.2 billion per month. So you got about 800 million each month that is shortage. It's increasing the RNYP. So, but we said that the only thing that can happen is that we could just be insolvent, but to be closed in terms of Section 21 of the Act, we cannot be closed. We still need to continue as an Act. And that's my point, that day zero wouldn't happen because there's money coming in. But the problem is, hence you end up with this 180 days, because in the absence of money, your age analysis for NYP just increases. That's a discussion for another day, actually, because that's very important. So if I answered that part into day zero, letter of comfort. So the directors of an entity are liable to a certain extent when the liabilities of an entity exceeds its assets. Company is illiquid. As directors, you are trading recklessly. In fact, immediately your liabilities are more than your assets, and it's a problem. Then you are trading recklessly, you'll be charged. So too, because then the people who said, we don't want to join RAF as directors because of this risk. It's just from the word go, the entity is insolvent. So the letter of comfort was made such that the directors are covered, that it's not your thing, it's the Act. Be a director, you will not be charged for trading, trading recklessly. So each year would see into the financials say that it's not solvent. The RAF would draft to the minister. The minister would writing to just saying we're exempted, feel free. That letter of comfort is what standard thing. And maybe to add to it, with the change in accounting policy then, these liabilities seem reduced. I've expressed my view on them. And we now know what then happened. When I was saying, no, we're not that bad, there's no need of a letter of comfort. That's another implication of bringing IPSAS 42, because it creates this false, in my view, thing that we are fine. We are really not fine. Take me on, because I said there's really practical claims that you can say they should be booked in as liability. So then this improvement, artificial improvement, resulted in us no longer issued the letter of comfort. Liabilities and assets, I think I've covered that in the letter of comfort. Actuarial services stopped. My extension, which one do I come with? I think I'll let Mr. Charakupa, language of parliament, Mr. Charakupa, take us through the why actuarial services stopped. But before he does that, I'd like to talk on my extension. Very important. Very, very important. And the link to the CO you are saying. So, I joined RAF on the 1st of October 2015 as a JM Finance on a 5-year contract. As old as then, my target was come 2020 when the contract expires, the plan, that'll be fine. And then at that stage, by the way, the CEO was Dr. Eugene Watson. The contract will say you get a 5-year contract, not renewable. 5 years, you're gone. That's a risk I took, and I knew I came from another entity as a finance director. I spent about 8 years. I was joining this one now as GM Finance, and I'm very strategic in terms of just so. Then there comes a clause in terms of, I think, board motivating that you've got institutional memory in the general managers. I came as the general manager. It was a newly created position. Actually, you've got sorry. You had executives, and then they created a layer for general managers, so that executives would focus on the strategy. The general managers would then look into operations. They had very brilliant layer of a highly qualified, experienced team there, and then you've got senior managers, all of them supporting. I remember we used to have what we call leadership forums. I'm missing them. They're very just brainstorming, and but back to your point. So I don't know what here. They came up a clause in the policy saying that general managers' contracts could be renewed for a similar, for a period not exceeding their initial period. In my case, 5 years, 3 years, whatever. So, and then they should prove performance, which is we do performance appraisals. Ours was very advantaged because now I'm a GM. I acted as a CFO for a longer period. So when this clause comes, it gives an advantage in terms of performance. You cannot question it's there, it's evaluated. But I mean, I'm now operating as a CFO and doing very good. Actually, I remember 2019 we came to Parliament to present. There was an opportunity, and just things went good. What is it, March 2020, clean audit under my leadership. Now you make me brag. 2020 as the team, this team, they just and everything. So I'm coming to your point. So what they do, and this is very important, if a general manager or an executive, you want to retain them, give them an extension a year before, even 18 months, because if you don't do that, you're going to lose them. They're going to start looking for a job. But there's some, hey, by the way, we want to retain you. We've got something else already. So in 2019, September, some general managers whose contracts were coming to an end that qualified to have their contracts extended were extended. So mine, we had an acting CEO in the name of I don't have the money to pay for my suit. Acting CEO before the CEO from Department of Transport came in. Motivation was done. It's a very many layers. You make a motivation, it goes to HR, it goes to CEO for approval, gets approved. So my thing was approved that now my contract is ended for the next extended for the next 5 years. There's many GMs, others got 6 months, whatever. This is now in 2019. On the 9th of September 2019, on a Monday, we get a new CEO. Okay, now. I get emotional in this part, not in a bad way. I'll come back. It's not a bad thing. It's a good thing because I mean my contract wasn't renewed. But give me some time, please. So, 9 September 2019 is on a Monday. New CEO comes from the department. By that time, my contract has been renewed. We work. In January 2020, I'm not sure whether I'll bring again, we went to London. Me, the actuarial, the CEO, gosh, you've got time. CEO, one person was a GM region, another person was a GM risk part 2. Went to London to source insurance. It was an annual event, so CEO would go, CFO and the actuaries. It was a standard thing for them, but we were joined by CEO. It was a new thing, but he really had a very good input into that meeting, I must say. But back to my point. In February 2020, I get a letter from the CEO saying that your contract that is expiring on 30 September 2020 will not be renewed because we're going to restructure, it says. And this applied to all the GMs got these letters. I look into this letter, but my contract has been renewed for the next 5 years. I've got the memo says so. I'm like, does the CEO know that I've got this? And then he says, no, your contract will not be renewed. And HR, what's going on? They say, that's it. So this contract is, then I ran immediately to CCMA just to get clarity in terms of maybe there's something wrong with it. Went to CCMA saying that they say my contract not renewed, yet it is renewed according to this. Went to that thing, they challenged it. CEO said it must be challenged that he's right. Because my question was, how do you say my contract not renewed that has been renewed? Secondly, how do you You don't know the restructuring, because the reason for saying it will not be renewed, you don't know the reasons. In other words, you don't know if you're going to restructure. First restructure, get the structure, then put people in it. You cannot say to me, I intend restructuring, then I'm getting rid of you, for example. So it was a very easy case to win at court. They were represented, I must mention this one, because it was a very strong case, and it cost by Advocate Kasim, Nazir Kasim, and an attorney. Yeah. We won the case, came back. Then from there, my life has completely changed. That I have. Okay. Can we address this part at the end of the meeting, please, so that we work? I'm sorry.
No problem, Mr. Songelwa. So, no, that's fine. So members, can I make a proposition? Because I think you'll also need some time. So I wanted to take Honorable Madla. No, please don't apologize. It's really okay, Mr. Songelwa. You don't need to apologize. Yeah, are you fine to continue? Okay. So thanks, Honorable Ment. I don't know if you've got your whip with you for. Sorry. Okay.
Sorry. Yeah. Do you want me to address the actuarial services one?
Yes, complete that question. Yes, that's important.
All right, thank you. So yes, I think in 2020, around there, before 2020, the RIF utilized a panel of actuaries for individual loss of income calculations. And then in 2020, there was then a motivation. I think it was championed by the previous COO and the outgoing CEO as well. I think I also assisted in terms of the input of the calculations, in terms of the cost benefit of insourcing the actuarial function versus continuing with the panel. And I think the documentation is there, but the determination at that point was there were going to be savings generated by insourcing the actuarial function on loss of income calculations. So it was then capacitated from I don't remember if it's 2020 or 2021. So since then, that function is internal. Yeah, I think in terms of the capacity, I think it's a continuous process of them then assessing if they have adequate capacity. But the move from that being a panel previously to then that function being insourced and then being adequately capacitated, it did. I mean, at the time I was there, I can say it did generate savings on a year-to-year basis compared to, I think it was about 10,000 Rand or something like that per report on the panel side. But after insourcing, it was then the salary of these employees on a monthly basis, no matter the number of reports. So yes, I can confirm that. Thanks.
Thank you very much. Thanks, Honorable Ment. So I wanted to say let's go with Honorable Skosana's proposition to go until 12:30, and then we'll break. The house is at 3 today, is it not? It is at 3. Okay. Yes, no. Yeah, you can, Honorable Ment. As I was asking if your whip is somewhere near you. Honorable Madlala, we'll take your questions for 20 minutes and then we'll break. Must we pass you? Okay, Honorable Atkinson, it's your turn for 20 minutes and then we'll go on break and return later. If I may just beg your indulgence, Mr. Songelwa and Mr. Charakupa, so just try and be concise with your answers. I know I had also said pretend we are chatting, but maybe not so much. Okay, thank you.
Thank you very much to both of you for attending today and helping us to clarify a lot of issues. As I said in the last meeting, the one thing that has become so apparent has been the incredible pain that has been created by the former CEO and the senior executives, and we see it again today. And I'm terribly sorry for you for what you've obviously been through recently. I mean, it really is quite appalling. Right from the destruction of hospitals, claimants not being paid out, and staff members being bullied, basically, because that's in essence what this is. So I'm very sorry for you for what you've been through. The issue I'd like to bring up, and the chairperson did litigate a little bit, is this issue around the CIO and a treasurer. Okay. Now, my understanding of how the Road Accident Fund works was that you get your approximately 4 billion rand a month comes in from the fuel levy, and that money should really be paid out. And in essence, all you really should be doing is managing the movement of money from the fuel levy to paying the claimants. And in essence, as you said, because the claims tend to exceed the amounts of money coming in, you really shouldn't be having a lot of money sitting around. Okay, so my understanding on that would be, knowing the difference between a treasurer and a CIO, you actually really just need a treasurer. You know, in a sense, you need someone who will run a decent treasury. When the money comes in, they get the best possible rates of return on it, and then they manage the liabilities, obviously, and pay that money out over the time. Employing a CIO implies that you have a lot of money sitting around. Okay, and the former chairperson actually admitted that at the end, when he last appeared at the committee, that there were some billions of rand in an account that he didn't want to make clear to us. And obviously you require a CIO to be able to manage large chunks of money, which really, to be honest with you, is kind of quite outside the terms or the terms of the CIO of the Road Accident Fund mandate. I mean, you guys shouldn't really be acting as a bank. So I was just interested whether there was any question that was raised about why a CIO. Why would something like RAF need a CIO? Because it actually doesn't make any sense if the business has been properly run. You just need a treasurer, not a CIO. Thanks.
Thank you, Honourable Atkinson. I can answer my view on the appointment of the CIO for the Road Accident Fund. The RAF is not ready at this stage to have a CIO at all, for the reason that, and I'm not looking at the person, I'm looking at the position very critically. At any point in time, the money we are receiving on a monthly basis from RAF is not enough to pay the claims that are due and payable. That is RNYP, for example. At any point in time, we've got RNYP. So doing any investment, any form of investment, you can only do that at the expense of the claimants. For example, you borrow me 1,000 rand. When I get my 2,000 rand, instead of paying your money, I put in the bank and I come and say to you, I'm making interest. That would not be good interest because it's done at the expense of the thing. So at this point, there's no need of a chief investment officer because it's just money coming, you pay, come in, pay in. What you do is really just high level. You take RNYP, you age it 0 to 30 days, 31 to 60, 61 to 90, 91 to 120, 120 to 150, 150 to 180, then for plus 180. When the money comes, you look at that age analysis and balance, they say it's about 15 billion. I mean, no, just practical. It's about 8 billion that you have got your RNYP in. So you say, I've got 4 billion this month. How do I distribute this money to this 8 billion? To answer your thing, the CIO, what then they did so that to appear to be doing something, and this is saying, instead of paying, because we before 2019, for example, we look into that age analysis, we knock off the old claims, go to a point that would have like 120 days, maybe 90 if possible, because the idea is to pay as many claims as possible. How would I, if I'm in that, I've got to wait to be, okay, back to my story. So to answer you, there's no need to invest. You need to use the money to pay the claimants until we get a point where we got a legislation that says you can pay in installments. So if somebody is to be paid 1 million rand, you're not going to pay now. It will be in the bank. Then you've got a chance to mobilize that money in the investments, use the interest, whatever. As of now, you're really, in my view, to do that is not sensitive decision. And come and say, for example, I've made so much interest, yet that person in my rural area has got to wait, and it's got nothing to do with lawyers in terms of just the claimant direct not getting their money now. 180 days is 6 months, so that should be fought. That it should never happen. But I know I'm nothing. So the CIO, not necessarily at this stage. Just need somebody to manage the money coming in, pay the money coming up, and do that thing just like in and out until we were there. So there's no need of a CIO and the rough structure under the circumstances to invest what? Because the money we get, keep it in call account for a shorter period, we blow it. In fact, I can show you the thing. Now to take me to another point, perhaps. I was looking at the interest in our income statement. I've made a presentation of it, page, the income statement. This is 118 and 117 of my affidavit, perhaps 117 of my affidavit, just to say something that's very important. 117, and that will take us to VS 17. I'm not going to be long.
I feel like the cringe here. Everybody looks at me. They're like, "Oh, that bad guy's gonna beat me."
Jay, can you stop the clock for a moment?
Maybe in the VS 17 annexures, VS 17, high level, and I'll close the thing. VS 17, and to fast forward it so that we got nice information, slide number, they're not numbered. The one that says historical financial information. So it's in the, you leave all these other ones, historical financial information for the period. Goody. Historical financial information. Can you see that one? Not going to be long. I'm just emphasizing the point. We find that one. So if we go to the income statement of that, it answering the question of the CIO and the necessity. We've put in there 2021 to 2025. We left 2020, and that will be very interesting as well. So in 2021, look at the bottom number 3 there. We had a surplus of 1.73 billion. That was just a short-term thing. The following year, we had a surplus of 428 million. Because your two surpluses were just a short-term thing, you under. We mentioned that thing. You panel of attorneys to process things. What is the link? Your forms are coming. Your new form. You are discouraging claims from coming in. Put it that way. So your claims in 2.1. Your claims expenditure, for example, 37 billion. Look at it. It was lowest ever 2021. 44.53. It goes up now. You're 2.1. But what I'm saying to justify the CIO in 2023. The reality comes, your 2.1, your claims liability becomes 53. Oh, I'm carried there. Thank you. I'm carried there. 53, you make a deficit, big one. That wipes off whatever surpluses you had. But let's go back to 1.2. 1.2, that's my interest, your interest. For 2025, at this stage, this was unaudited, but it's more or less there because interest from the bank statements. We had 678 million rand as interest. A year before, 2024, 697 million rand as interest. 284 to 223. If you to take years before 2019 for the Honorable Mende, these interests were never this high because money would come in, we pay, money will come in. How do you accumulate that money? What is even worse, if you compare to your bank balances, for example, you say, okay, let me see my bank balances at the end of the year. You go to another slide that says cash flows, high level. Cash flow statement, not going to be long. Cash flow it will answer my question. The RAF receives the money on the 25th day of the month, for example. So when you receive that money, we make sure that by 31st March it's finished. Not finished, it's because you got 3 days. So in March, you'll have a bigger balance because but generally you chase that money away. So 2022, 868, the balance is there. Number 6, have you seen the cash flow statement one? You had 4 billion. That was another thing. It was how would you have so much money at the end of the year? 4 billion. Then it was corrected the following year. We had 868 million, 2026, 30 million, 815 million. We closed 2.1. Now done in March to show a lesser balance. But in the process, if I can say this, you've cheated the claimants by keeping the money in the bank accumulated interest. It becomes a focus because CIO, that should not be there, is now focusing on say, okay, I'm justifying why the CIO is there by generating the stress. My bottom line is, I'm saying this from an accounting point of view, as a government entity, we should pay what we get to that thing. If Sasao get so many billions, they were to keep the money, we made a lot of interest, but unfortunately we've got to take the money and pay the people in the street. Same thing at RAF, it shouldn't be accumulated so much interest. So there's no need of an investment officer at this stage, too, because RAF is not ready for a chief investment officer. Sorry, I'm not...
All right, so no, thank you.
Then could I ask you the question, what was he doing? What was the CIO doing then?
So the CIO came as a treasury specialist, treasury in the office of the CEO, took over the acting general manager treasury, which was a senior manager function really. They should not have been that because senior manager was enough. You need more portfolios. So what would do? Money coming in, money going out, the check after the monies that are being paid, motivated, I must give it to that, motivated for this 180 days because the reason behind 180 days is that we should not pay anything less than 180 days was to say this new team, this new leadership, we need some time to get our act in order. Court, can you give us 180 to delay the payment? Once we get it in order, we'll go back to just paying whatever. Then it became like a policy now that no claim will be paid before it reaches 180. So that 180 gave a chance for the CIO to sort of mobilize the funds and whatever. Also now creating this thing of taking actuarial department, for example, unlawfully. No, not unlawfully. That's a harsh term. What did I write? Unofficially, because it's just, and then and then that is taking actuarial, and then there's this actuarial team for claims. I think it did mention for operations, not the one for corporate, is under the CIO as well. Whether, this I must say as well, unlike politicians, somebody would be a pharmacy and have accountants report. Whether it's got the actuarial qualification to head the actuaries is a question for another day. I'm not getting personal, I'm just saying. So he then heads the actuarial department and others and others and others. Something I think it should be revisited and be looked into whether is if it for not personalizing the position fits the person, so to speak. That's my comment.
Now, when the CIO came and spoke to, when the former CEO came and spoke to us, he spoke about obviously a lot of money being held, and he didn't really want to disclose where it was because he was worried that lawyers were going to come and take it. There's also been some discussion around what they call the Investec bank accounts. And there seems to be some issue around whether they were used to kind of squirrel money away or whatever. I was just wondering if you could maybe give us a little bit more clarity on the Investec bank accounts.
I'm not sure. I don't say it's an urban legend. I don't have facts around it. Maybe it's there, maybe it's not there. I really do not know. But what I can say, though, is that on this cash flow that I've presented in VS 17, these are the monies that get audited by the auditors. What the auditors do, they send confirmations to bank independent of us. You just tell them what banks. They will schedule to all banks. In my time, I don't know what AGSA does. You would send to all banks, even the ones that the entity does not serve on. Then you'll be surprised when the bank comes and says, hey, there's not many banks in South Africa, that there's a balance of something by this entity in here. But to answer you, all the RAFs banks that are audited are shown in there, all those monies at the balance in call accounts, in retail accounts, etc., etc. I am not aware of the monies that are Investec. They may be, I do not know. That could be maybe, but I don't know.
All right.
Sorry.
And then just another point, you mentioned the fact that you thought that you correctly say that there needs to be a legal transformation at the Road Accident Fund, because the way it's set up at the moment will make the organization insolvent. So there needs to be a new way in which things have been done. And you speak about the RAPS bill as being, potentially the silver bullet. But would it not, as the RAPS bill is constructed at the moment, require the state to take on that massive liability? That, is the RAPS bill actually the way, or is there maybe a different way? But the concern around the present RAPS bill that's put out there is, I think it's no fault. That it could put a massive liability on the state.
The easiest way to address, you got RAFs when new bill coming in, and you got RAF, you ring fence the RAF as is. In other words, you say 31st December 2026 to be practical. No, make it coincide with the year end. 31st March 2027, not 2026, really practically. 2027, there'll be a new entity created called the Road Accident Benefit Scheme Administrator. Like SASSA administrates grants on behalf of the Department of Social Development. So you create this entity to administer RAF claims. And at that point in time, there's not these millions being paid, it's monthly. We talk about standardizing the finger, this, just so that it's equal, whether you're rich or poor, you just everybody gets the same for the accident they have had. But the point is, so then you start on a clean slate for RABSA. So that doesn't really come with this baggage of this, otherwise you're continuing with this problem. So ring fence this one, saying that when we've paid we serviced the clients or claimants of RABs monthly, because if you're paying monthly, you now accumulated money in the bank, interest is just growing nicely, then you spill over on this servicing this debt for RAF long in perpetuity. And otherwise, if you change RAF to RABs, will be a problem or something. So start a new thing altogether, whatever, and then create this one, ring fence it, as I say, over a long period, and that government might throw in maybe 5 billion per year, that whatever. There's no money in South Africa, but if it's nicely managed, okay, that is another point about the interest of the country. But to answer you, it's doable, but it needs to be properly blended, separated from the entity, so that this is an old debt, this one is new and up and running.
To you, you showed that rather effective graph, which showed the increase in the claims being paid out, quite a dramatic increase, and also obviously the cost and the legal cost, because obviously there were fewer claims being paid out, but a larger amount. So obviously what we have seen over the last couple of years is a massive increase in default judgments against RAF, and obviously some very high figures that RAF has had to pay. Are those included in your numbers? Are you taking into account the default judgments?
But they,
Sorry, microphone.
though he will answer, just to give a background, the default judgment will be included because you take the total claims settled, so to speak, including both default judgments and et cetera, et cetera. Hence, in his numbers is showing that increase, one of the contributing factors to the increase in the average claim, average claim, is exactly that, because of the default judgment. Something that would have been settled for 100,000 rand now gets settled for 150, because the plaintiff attorney, the one that represents the claimant, says, I want 100,000 rand. There's nobody from RAF to say it should be 50,000 rand or whatever. You, in the absence of, there's no capacity to do that. We said the state attorneys are not enough, state to be corrected. And so even he said 100, I said we might as well make it 120, because I'm not challenging here. And then the court says, actually, it makes sense, get your 120,000 rand. So to answer you, the default judgments are included in that. It's just that we don't have statistics exactly to say how many, how much, and when, at what period, high level. But Mr. Charakupa will also add. Thank you.
Sorry, just one last thing. Do you have any idea what the cost has been to RAF of the getting rid of the panel of lawyers, of the fact that they were got rid of without really a proper process being put in place? Because I know we talk about the state attorneys, but I mean, they just were completely not set up to deal with the quantity of stuff that came through. So there was an incredible cost to that. But I mean, do we know, have we any idea what that was?
That's a very good question, actually, because my understanding is that I don't even think that the cost of doing away with panel, their costs were 100% calculated to create a provision for them. Because we brought in back the files without really saying how much do we owe them. And therefore, there's a highly likelihood that there are invoices that are in their possession that still need to be paid and be provided for in our books. I must say, of late, I'm excluded from the until I left, I was excluded from the accounting matter. So this is what I'm saying. I would not be able to say, let's go back and get this number and put it there. So I do not know the number, but I do suspect that the provision for panel of attorneys invoices are understated. Just that I don't have evidence to say it. I'm sure there are previous panel of attorneys they said we're still owed, and this thing with us, and RAF has not accounted for that. That adds to the understatement of the liability as well, and the expenses of the RAF in the income statement. I'm just saying. Thank you.
All right. Thank you very much. Thanks. I appreciate it.
Oh, okay. Thank you. Just to add, I think on the point of the default judgments being included in the graphs and the tables that we shared, yes, they are. In this table that I shared, the second page with payments, this is the total payments paid by the RIF in each given year, and it's directly from the RIF's payment system. So all payment done by the RIF goes through the payment system, and this page of the annual report captures all those payments. So your default judgments, your inflated claims, everything will be in there. And I think the other comment on the rough on the legal costs, just two paragraphs. I think in terms of the as a 2022, I think it's VS 17. But I can just refer as well, maybe to the affidavit. Yes, or to the affidavit. Let me just go. Sorry. This one. No, VS 18. Sorry. Or the paragraph. Yes. So paragraph 107, page 35. Paragraph 107 on my affidavit. It's in line with VS 18 on page 12. Yeah, it's same thing on page 12 of VS 18. So what we did back then in terms of trying to calculate the cost of the inadequate capacity was to then say, what's the reduction in legal cost? So in page 12 there, so if you look at the top, there's a table which says net incurred losses due to operational inefficiencies. The second line is comparing the reduction in legal costs from 2020. So in 2020-2021, legal costs reduced by 5.8 billion compared to the 10.8 in 2020. Then in 2021-22, it reduced by 2.9 billion, right? The second line of the table. But at the top there, if you then look at the cost of the excess payments due to default judgments and inflated claim settlements, in the first column, 2020-2021, we estimated that at 14 billion. In 2022, we estimated that at 17.6 billion. So the last line there then shows that the 8.1 billion plus the 14.7 billion gave us at that point a 22.8 billion. So that was the combined cost. What is available, I think, on the RIF system, what you can see directly is the default judgments, because those ones are indicated, you can see them. But the cost of inflated claim settlements, because of claims not being defended and settling at either 2 times or 3 times the fair value, you don't see that because they are not written default judgments. So you see them in the aggregate number. But this just gives an idea is at end of 2022, 31 March 2022, our estimates was lying around 22.9 billion for the combined cost. Yes, I think that would be my comment on there. Yes.
Yeah, last one, and then your time will be up.
No, for sure. But if I can make the point, that's only for 2 years, from 2021 and 2022. So the number could be considerably higher if we take it to today's dates. It's 22 billion. Thank you.
So may I add, thank you. May I add, there's something that I think I did not see it as explaining it thoroughly. On paragraph of Mr. Charakupa's statement, paragraph 110, there's a table up there that I want to clarify something. We've been talking about that the legal costs at one stage, or rather for the year 2019-2020, were 10.8 billion. We have said that. And then we went on to saying that in 2021, these were reduced to 4.9 billion, and leaving then a savings of 5.8 billion. And this has been said, and it's true. The numbers are there on 110 and that table above. What I wanted to highlight, though, very, very important is, I'm not sure it was said, I just want to clarify it, because, so if you go to claims processed, which is a challenge with service delivery, the average cost per claim legal is 49,000. I just wanted to highlight that, very, very important for the record, so that we understand the context of the 10 billion. We can go on further, actually, in saying it goes on to the following year, spent 7.8 billion. The number of claims are now 107, 193. What is the average per claim? I think Mr. Charakupa did say it. It's 73,000 rand per claim on legal costs. So much as the money is going down, but what is worrying is that the cost per claim is becoming expensive. So the context, when we say we've saved 5 billion rand, and with that thing, I'll leave it to you. I think take it further.
Sorry, thank you. Yeah, just the last point on that. I think members were given an additional annexure like this one, so that captures what the page you was saying, and I think it includes 2023 and 2024 as well in terms of the cost per claim, legal cost incurred per finalized claim. Thank you.
So, yeah, we're completing now. So basically, the average cost per claim at 258,000 claims settled was 39,860. At 63,015 claims, it's 110,908. So there are two corresponding numbers where the cost per claim has gone up. So there's legal costs. So we know the RAF now has been paying progressively more per claim in terms of legal fees, but also in terms of the actual claim itself. It would be interesting at a later stage to see what the pattern is with service providers as well. Okay, let me thank the honorable members and Mr. Songelwa and Mr. Charakupa. We will reconvene at 6:30. So I would like to get everyone out, and you, because it's a long day, out of here at a reasonable time. So if we can work on the length of those answers in the meantime, please, I would be eternally grateful to both of you. Like I said, I know the matters are a bit complex, but it's also important that we get to the nub of the issue so that the members can get at least 5 questions in at the very least. Thank you very much. Thanks, honorable members. Honorable members, there is a provision downstairs. Yes.